Regarding one, I am facing complaint. Garment. Regarding the season, I am facing garment.
One second. One second.
Regarding one, I am facing complaint. Garment. Regarding the season, I am facing garment.
One second. One second. What does the DNA report say?
Damage complaint. Garment.
What does the DNA report say?
Damage that is exhibit garment.
That supports the prosecution.
That is exhibit.
But my whole contention is only on the DNA report and collection of the my whole contention is only on the DNA report and collection of the samples by the from the by the police.
As of now, the statement of the victim is against you, and DNA report is against you. That supports the prosecution.
That is exhibit.
But my whole contention is only on the DNA report and collection of the my whole contention is only on the DNA report and collection of the samples by the from the by the police.
And now, the statement bail only we see there is a prima facie case or not, in spite of a conviction being recorded. Supports the prosecution.
That is exhibit.
But my whole contention is only on the DNA report and my whole contention is only on the DNA report and collection of the samples by the from the by the police.
And now, the statement bail only we see there is a prima facie case or not, in spite of a conviction being recorded.
That is exhibit.
But my whole contention is only on the DNA report and my whole contention is.
Yes, please proceed. Yes, we'll hear you. Yes, tell us. Yes.
The undergarment and the black skirt. And my defense there in the data trash act. So then this
Yes. Anything else? Take note. It's an application seeking for suspension of sentence and bail by the sole accused. The case of the prosecution is that on 11th February 2000.
My lord, I pray to withdraw his plea.
No, we will not allow it.
Well, kindly allow me, my lord.
No, we will not.
But
we are not getting into this habit.
No, my lord, I'm very sorry,
If
but
you want to ask, no,
but I'm very sorry. It is not a question of my just praying if it is my condition. But my lord, if I will argue this matter finally, my kindly may permit me to withdraw this application at this junction.
They have heard you. You rejected it. You don't want to get into this bad habit.
No, my lord.
If you want, please listen.
Ji.
You don't want to.
No, my lord.
We are asking you a question. You say, please permit me to argue. To argue, no.
No, my lord.
So kindly listen to what we are saying.
Yes.
If you want to withdraw, you should not argue. You cannot argue and see the mind of the court and then withdraw.
No, my lord.
That's not permissible. We are not going to be a party to such tactics.
No, my
We are
lord.
very clear on that.
No, my lord. What?
If you want to withdraw, don't argue.
My lord, but
You can't argue and then see what the judge is saying, how he is going. If he is against you, then withdraw. Then again, 1 week later, you will file. You can't
No,
go on
my lord.
wasting a court time like this.
No,
Bail applications are being heard hundreds of times before hundreds of judges. You think the criminal law will function like this?
No, my lord, but.
That is why we have thousands of bail applications which are not in being heard because of this reason.
But whatever, my lord, when
You argue.
when we argue, my lord, it is it is from the it's a common experience when we find that it is not coming our way. I pray to just withdraw, my
I
lord.
don't know what kind of experience you have, but as far as we are concerned, our experience is we are
No,
not going
my
to
lord.
encourage such kind of tactics.
But
Anyway, you have made a request, we have
for a while,
rejected
my
it.
lord, I pray for withdrawal of this
Yes, you have
application.
made a request, we have rejected it.
My lord.
February 2021. Mother of the victim made a complaint before the police that on 10th February 21 at 8:30 p.m. she had cooked food and after consuming the same, it was found that the victim was not seen. Later on, the victim came back to the house and told her mother that the accused had given a biscuit to her and thereafter committed a sexual assault on her. She disclosed the entire event to her mother. Thereafter, the FIR was lodged. Investigation was taken up. The accused was convicted and sentenced as follows. Thereafter, the instant appeal has been filed. The counsel and appellant submits that there are various inconsistencies in the evidence of the prosecution and therefore is entitled for bail. Considering the contentions, we do not find any merit in this application. The material and record would indicate, as has been considered by the learned trial court, that the DNA report goes against the appellant. The evidence of the victim is against the appellant. These two are sufficient material for us to conclude that he cannot be enlarged on bail. The rest of the contention, the appellant requires to be considered at the stage of final hearing. So far as the application for bail is concerned, we find no good ground to allow this. Hence, the application is dismissed.
If this. My lord, in this objection of the state is awaited on the suspension.
Will submit that he will argue the matter only after objections are filed. Hence, call out for 4 weeks.
Lord, this appeal was filed by some other advocate and we have received the NOC on the last date of hearing. That's why I seek some time to argue.
Appellant counsel seeks time to argue the application for bail. At request, call out for 4 weeks.
So this case may kindly be taken after 2 weeks because this case may kindly be taken after 2 weeks because there was a medical emergency as the counsel of the appellant's father is not well today.
At request, the appellants call out for 4 weeks. Both, all cases?
No, my lord. I'm in 10.1, my lord. I have filed 10.1, my lord.
10.1.
I have filed an application for
Your request
Sir,
is for which case?
No, my lord, I am appearing on 10.2, my lord. That is
Only for 10.
Sir. 10 in criminal appeal number 9055.
What's it? Okay. You are 10.1.
Yeah.
Please.
Lord, this is an application for grant of temporary bail, my lord, on the ground of marriage of younger sister of the appellant, my lord. Appellant Krishna Kumbhare, my lord.
How many accused are there?
My lord, there are five accused, my lord.
4 accused.
Five.
You are accused number?
Number 1, my lord. Krishna Kumbhare.
Yes, what is your accused?
My lord, this is temporary bail, my lord, on the ground
Temporary
of,
bail?
yes, my lord, for 15 days on the ground of marriage of younger sister, my lord, on 11/3/2023, my lord.
How many members are there in your family?
My lord, there are 2 brothers, father, mother.
Why your presence is
Malad,
You must be granted bail.
he is elder brother, Malad. Some of the ritual would be fulfilled by the,
The case of 302.
yes, Malad.
Yes,
Only 15 days.
not inclined.
So I'm withdrawing it.
This must have been. 1, 2. Your accused number?
I'm accused number 5, Harry alias Shivam Pawar.
Yes.
Lord, this the first application for suspension of sentence.
Yes.
The prosecution case is like this, that on 29/9/16 at about 7:30 p.m. in a crowded residency area, the 5-6 person, Lord, they were abusing the deceased, Lord, in front of his house. There was some, the deceased, Lord, he took a motorcycle and ran away from the house of his house. And after 200 or 250 meters, Lord, in a gully, Hulia, Lord, he was assaulted by the people, 5-6 person or whatever, Lord. What had happened, Lord, in this case, there are only one witness, Lord, as eyewitness. That is the wife of the deceased, Lord, PW1. The PW2, who is the Deva, who is the first informant, Lord, he came to know from his bhabi, that is the wife of deceased, that some incident Marpit chal rahi hai. She called him. He came over there, Lord, and they all went to the place of incident where the crowd was gathered. They have seen the dead body, and thereafter the FIR, Marg, Dehatinalsi Marg, and then thereafter the FIR was registered against 6 persons. The 5 are convicted, 1 is died during the trial.
5 is convicted.
Yeah, no,
There are total 6 accused.
total 6 accused,
5 are convicted.
5 are convicted, 1 is dead during the trial.
Yes.
Now, my lord, this appellant, Lord, as far as this appellant is concerned, in the very first information, that is Dehatinalsi, he was not named. Only 3 persons were named in the Dehatinalsi and even in the Marg.
Does the eyewitness narrate overacts against you?
No, my lord. There's no specific overtake because, my lord,
What
from
does the
the
eyewitness say?
my lord, from her evidence, my lord, she says, my lord, that she has seen the incident. From the evidence of the PW1, my lord.
She is which witness?
Pardon, my lord?
PW1.
PW1.
What is the overacts against you?
Lord, there's the only allegation what he made in the Dehat analysis, that I stopped the motorcycle of the deceased. He fell down along with the motorcycle, and the other persons, Lord, they assaulted by bricks and some stones. There's no weapon was used.
149.
149. No weapon was used.
Why
Only
did you
bricks.
stop the motorcycle?
Lord, it is alleged by the wife of the PW1 that. Pardon?
Allegation against you is that you stopped the vehicle and made him fall down.
Yes.
Why did you do that?
Lord, there's no such evidence, Lord, against me. What had happened? Lord,
That's
the wife
what
says.
you are only saying. Eyewitnesses.
Yes, my lord. I'll prove that by the evidence of PW1 itself, because she was not the eyewitness. In fact, my lord.
It's a different matter.
Lord, so there's no eyewitness. There was no mention. There's no intention, my lord, has been proved. That is the finding of the trial court also.
Please read
Yes.
the PW1.
PW1, Lord, I'll read. Lord, I'll read the relevant portion, Lord. Lord, it is, she deposed, Lord, in para 28. That, Lord, she was informed by a girl of the neighbor of
Please read our chief.
Chief, Lord. Chief, Lord, she has said that she has seen the incident and she informed.
How you overcome that improv?
Lord, in her own evidence, Lord, she says some girl was informed him telephonically. Then he informed PW3, who is the neighbor of the disease, neighbor of this brother of the disease. Then they all came together where the crowd was gathered. But they have, in fact, they have not seen the incident, Lord. That is what my submission is. PW1 is cited as a witness, Lord, eyewitness, but she is in fact not eyewitness. She had admitted in the statement also. Lord, in the deposition, Lord. Yes, Lord. मेरा 31 मिनट यह कहना सही है कि मुझे घटना के संबंध में पैराग्राफ 31 ऑनवर्ड्स मिनट
Yes, please.
यह कहना सही है कि मुझे घटना के संबंध में अन्य लोगों के माध्यम से जानकारी मिली थी। यह कहना सही है कि जब मौके पर पहुंची तो वहां पर बहुत भीड़ भाड़ थी। स्वतः कहा कि मेरे मोहल्ले में 2-4 लोग मौजूद थे। Then not further in para 2033, मुझे इस घटना की के बारे में जानकारी अन्य लोगों से मिली थी। उन अन्य लोगों का नाम से नहीं जानती हूँ, कहाँ रहते हैं, मैं यह भी नहीं जानती कि उन लोगों को से मेरी बातचीत हुई यानी घटना की जानकारी मुझे घर पर हुई थी और मैंने मनोज को फोन लगाया था। मनोज इज PW3, ब्रदर ऑफ द डिजीज। मनोज को फोन लगाया था। इस पर घर पे मैं और मनोज पहुंचे थे। तब मौके पर 2 पुलिस वाले आ चुके थे, जिसकी एक पुलिस वाले से पहचानती हूँ जिसका नाम हसन है। दूसरा पुलिस वाला जो थानेदार था मौके पर पहले से ही पहुंच चुके थे। हमको मौके पर जाने के बाद हमें वहां दोनों पुलिस वाले हाजिर मिले थे। What my submission is that after the incident somebody has informed police and dial 100. They already did. Look, this is not the evidence of the PW1 that she says that she reached after the incident is over.
That's what we are asking.
My lord.
Please understand. Form.
Yes, Lord.
She came.
Yes, Lord.
There cannot be a presumption on evidence. Correct?
My lord.
Now, in the chief, she said that she has witnessed the offense.
The reason. Yes.
Either to stop or we will talk.
Madam,
We can't.
I'm sorry.
We're not a market.
I'm sorry.
The examination in chief, he very clearly narrates that she has seen the incident and what happened.
Madam.
You agree?
Madam.
Huh? The chief, she said that she went to the incident, police were there. Somebody informed her she went to the incident. Is there any question you asked her whether she has witnessed the crime or not?
My lord, this is how we try to find out. She was informed.
You ask a question
Madam.
against her statement in the chief. In chief, she made a categorical statement she has witnessed.
Madam.
Did you ask her whether she has witnessed it or not?
But that particular question was not, a specific question was not put up.
You are not. So you
Madam.
are going on the assumption of the other statement.
Madam.
She
It
came,
is her
she
own
came
procedure.
on hearsay evidence.
It is her own
She-
procedure. Madam, I'm sorry.
Yes.
Yes. Lord, I'm sorry.
So you are going on the basis of assumptions. Evidence can't be interpreted by assumption. Evidence is a question of fact. What a witness says in the court. So the witness said, somebody informed me, I went to the scene. When I went to the scene, police were there. You can't draw an assumption unless you ask a specific question. Did you see the incident? Were you there when the incident took place? Did this Harry assault? Did he stop the vehicle? वो सवाल पूछना.
My lord.
Then you contradict the chief. Otherwise you can't go by other statements. That's our question to you.
Lord, what my submission is, that if you will put a direct question to the witness, that did you see the incident? Lord, she have already narrated, she has already, the Hatin also was already, and so Lord, she will not directly answer this.
That is
That
your
she will not-
legal acumen. How to get
Lord.
answers from a witness.
My lord, one thing, that is why Lord, this is how the question was put up.
इसके लिए होता है.
Lord,
To get it out from the witness.
so this is what the practice we adopt, Lord. Apart from that, Lord, he has not been named in the Hatin also first information.
Need not be.
My lord, there is no recovery, there is no weapon was used,
Need not
there was no intention, no manslaughter, there was no.
But the allegation.
That are right from the Hatin, right from FIR. Chief में हाँ chief में बोला है. I have seen this.
Kindly read the chief.
Lord, para 1 last 3-4 lines Lord.
पहले से पढ़िए.
पहले से पढ़ लेता हूँ. कक्षा 8वीं पढ़ी हूँ. मोहन चौक से मेरे पति थे. मैं अपने पति मोहन चौक से अलग रहती थी. मेरे पति और मेरे बीच 125 का मुकदमा चल रहा है, जिसके कारण मैं अलग किराए से रहती थी. दिनांक 29/9/2016 को शाम 7:30 बजे की बात है. मैं बाजार से अपने घर लौट रही थी तो मैंने देखा कि मेरे पति घर के सामने भीड़ जमा थी. 5-6 लड़के घर में गाड़ी उत्पाद कर रहे थे. उन्होंने घर का सामान टीवी वगैरह बिखेर दिया था. मैंने आरोपी को उत्पाद मचाने के लिए मना किया तो वो लोग माने नहीं. फिर मेरे पति अपनी मोटरसाइकिल उठाकर अपनी जान बचाने के लिए वहां से भागे. उनके पीछे मैं भी गई. थोड़ी दूर पर हैरी पवार ने उनकी मोटर गाड़ी पकड़कर संतोष पटेल घर के सामने गिरा दिया. फिर उधर से बल्लम, कृष्णम, पप्पू, एक लड़का ध्रुवे, इन चारों ने ईंट अद्धों से मारा. ऊपर से रूपेश आया. उन्होंने सीमेंट का एक बड़ा पत्थर उठाकर मेरे आदमी के सिर पर पटक दिया, जिससे उस तक वो आ गया. मैंने कहा कि उन्हें मत मारो तो उन लोगों ने कहा कि तुम भाग जाओ वरना हम तुम्हें भी जान से मार देंगे. फिर मैं अपने दीवर मनोज को बुलाया और उन्होंने पुलिस को फोन लगाया. But even I am not named in the first information. When she disclosed about the incident, I was not named. And there is no overt against me.
Course of investigation accused can be added.
There is no overt against me, my lord. Only I have stopped the vehicle, my lord, and nobody has seen. That is a crowdy residence area, my lord. The crowd was gathered. No witness from the locality was examined by police.
Must argue based on the
But that is the best available evidence I have.
You clearly narrates the incident. 149 is used. The overtake against you deliberately stop the vehicle so that the offense can be committed.
That has not been.
That is what the evidence has said.
There is only one witness, and that too.
See the second portion.
That is the total sum.
So what you should have counted in the cross.
Lord, I have traveled my level best to ask this question, whether she was really an eyewitness of the incident or not. And she had literally deposed me, Lord, that she in fact did not see the incident. She was called by someone, she informed me.
Where is that she did not see the incident?
Yeah. Lord, I'll read again.
Ah.
Paragraph 30 onwards, Lord. So how, Lord?
Para?
This para 30 and 33, Lord. That she is when the crowd was already there, police was already there. That clearly indicates, Lord, that she is after the incident was over. The police came already were there. So how can she be a witness, Lord, in front of the two police persons and the crowd of the locality? That is how we try to get the. That is how we try to suggest the witness, Lord, to speak the reality what had happened. And this is what the fact is.
Can we draw an assumption?
No, my lord, I'm not praying for that. I'm just submitting a fact, my lord, which is available to me before my lord. That is all. This is what the evidence. This is what the evidence available to me, my lord. That is the evidence of the PW1, and she is the only witness. There's no other witness in the case, my lord. The prosecution did not try the one witness of locality who was gathered over there. One nikah was going on, Lord, where the dead body was found there. Yes, Lord.
For,
He's accused number 5. Para 28. It is the cause of assumption, but for the co-accused Akshay,
Akshay.
done by his counsel.
Who is Akshay? He passed away.
No, Lord, sorry. This is for the Sachin. Para 28 is for the accused Akshay.
Kindly read para 28.
28, Lord. मुझे घटना की जानकारी मेरे पति के मोहल्ले की एक लड़की ने आकर दी थी। यह कहना सही है कि घटना के पूर्व से अपने पति से अलग निवास कर रही हूँ। यह कहना सही है कि उस समय मेरे देवर के यहाँ जा रही थी, मेरे पति के यहाँ नहीं जा रही चाहती थी। यह कहना सही है कि रिपोर्ट मनोज ने लिखवाई थी, लेकिन मनोज के साथ मैं भी गई थी। यह कहना सही है कि मैं पति की मृत्यु पर घटनास्थल पर पहुंची थी। पत्नी की मृत्यु के बाद ब्लड, यस, यह कहना गलत है कि मैं उसकी मृत्यु के बाद पहुंची। यस ब्लड, रिपोर्ट मनोज लिखाई थी, लेकिन मनोज के साथ मैं भी गई थी। देन यह कहना गलत है कि मैं मेरे पति की मृत्यु के बाद घटनास्थल पर पहुंची थी। यह कहना गलत है कि मैंने घटना होती हुई नहीं देखी। She has denied if the question was put up. That is what I was trying to submit, Lord. If I'll directly put the question, she will certainly speak like this. Because she is the wife of the DG. I'm just,
Yes, we can talk at assumption.
that is what we tried. In further next 30, paragraph number 30, it was tried. Yes, she narrated the incident. She reached when the crowd was already there, policemen were already there. So it clearly indicates that she was not, in fact, the eyewitness of the incident. And the person who were really eyewitness of the locality, incident took place at about 7:30 p.m. One nikah was performing in the adjacent area. There was already a crowd. And it has been specifically alleged that from the house of the deceased, the place of incident is not visible. It is around 200, 250 meters. Because he came out of his house, deceased, took a motorcycle and ran away. What had happened after 200 meters, 250 meters is not been narrated by any of the madam. That is what my submission is.
She narrates that she has seen the incident and the cross also she denies your suggestion.
She has been made an eyewitness. This is what my submission is by prosecution. Because there was no witness, available to the investigation officer.
Consider that at the bail stage in post-conviction.
One more submission that the investigation officer is not examined in this case. The investigation officer himself was not examined because he was absconding in some criminal case. So for want of his availability, he was not examined, he was given up.
One of the allegation that the eyewitness, the only eyewitness was not there, has been dealt with by the learned trial court by in para 22, my lord. It may be permitted to read aloud para 22. घटना के संबंध में प्रत्यक्षदर्शी साक्ष्य के रूप में पेश एकमात्र साक्षी माया चौक से अभियोजन साक्षी क्रमांक 1 के कथन न्यायालय में कराए गए। इसने अपने कथन में बताया है कि वे आरोपीगण को जानती है। मोहन चौक से उसका पति थे। वे अपने पति से अलग रहती थी। उसके पति और उसके बीच धारा 125 धन प्रक्रिया सहायता का केस चल रहा था, जिसके कारण वे अलग किराए से रहती थी। दिनांक 29/9/2016 को शाम 7:30 बजे की बात है। वे बाजार से अपने घर लौट रही थी तो उसने देखा कि उसके पति के घर के सामने भीड़ जमा थी और 5-6 लड़के घर में गाली गुफ्तार कर रहे थे। उन्होंने घर का सामान, टीवी वगैरह बिखेर दिया था। उसने आरोपी गण को उत्पात मचाने के लिए मना किया तो वे लोग नहीं माने। फिर उसके पति अपने मोटरसाइकिल उठा के अपनी जान बचाने के लिए भागे। उनकी पीछे वह भी गई तो थोड़ी दूर पर हैरी पवार, विच इज द प्रेजेंट एप्लीकेंट, ने उसके पति की गाड़ी पकड़कर संतोष पटेल के घर के सामने गिरा दिया। फिर उधर से बल्लम, कृष्णा, पप्पू, ढीमर एवं एक लड़का ध्रुवे, इन चारों ने ईंट के आधों से मारा। फिर उधर से रूपेश आया, उसने सीमेंट का बड़ा पत्थर उठा के उसके आदमी के सिर पर पटक दिया, जिससे उनका भेजा बाहर आ गया। साक्षी ने आगे यह भी बताया कि उसने आरोपी गण से कहा कि उसके पति को मत मारो, तो आरोपी गण ने कहा कि वह यहां से भाग जाए वरना उसे भी जान से मार डालेंगे। फिर उसने अपने देवर मनोज को बुलाया। मनोज आए, उन्होंने पुलिस को फोन लगाया। फिर पुलिस वाले आ गए। फिर पुलिस में रिपोर्ट की। उसके पति को घटनास्थल पर ही मौत हो गई थी। घटनास्थल से ही उसके पति को अस्पताल ले जाया गया, वहां उनका पोस्टमार्टम हुआ।
इंसिडेंट होता है।
Lord, in fact, not. I am not convinced that after crowd the incident will took place, Lord. Even the police personnel were present before she arrived at the place of incident. She has specifically narrated that the policeman and the crowd, no witness from the locality was examined.
He went there was a crowd.
My lord.
There was some interaction that took place.
Right, crowd with two police persons. He had named one police person also, my lord. That she knows one police person. 2 police persons were present along with the crowd. One more paragraph, not paragraph 20 of this PW1, Lord. I'll read, Lord. भीड़ में आरोपी गणों को पैराग्राफ 20 में, भीड़ में आरोपी गणों को छोड़कर हमारे आसपास वाले लोग थे। भीड़ में मोहन की जहां लाश पड़ी थी वहां भीड़ लगी थी, हजारों में थे। मैंने मोहल्ले वाले लोगों को छोड़कर शेष को नहीं जानता। मुझे वहां पर मनोज के कोई दोस्त नहीं मिले। शकील और नस्को नहीं जानती, वे लोग वहां पर नहीं थे। Shakil and they were in their 161 statement was recorded as eyewitness. They did not support the prosecution case, Lord, but here she also said that there was a crowd of thousands and the dead body was lying. That suggests, Lord, that she has not witnessed the incident, in fact. As there was no witness to narrate about the incident, Lord, the wife, Lord, has made as an eyewitness, Lord, cited as eyewitness. Even PW 3 Manoj, who is the brother, he was also cited, but that was disputed by trial court. He has specifically mentioned that he has not seen the incident. The PW1 is the only witness, Lord. There is no other witness. There is no Caesar. IO has not been examined. Lord, that is what the trial court did. They find it sufficient, Lord, and convicted me. There is no mens rea, there is no intention, there is no penalty. The ingredients of section 302 is not a threat act. No weapon was used. It is not a plea plan murder. And for what purpose? Nobody, no witness from the locality says that I did it. It is only the wife. It is only 149. Look, it is only the wife. She says like this. It is only the wife. My lord.
The fatal blow.
That is what my submitted analysis of record available to me.
Just because there are independent witnesses which could have been examined, that cannot doubt the evidence of the eyewitness.
But that is what my submission is, that she is not eyewitness.
Can't be a ground for.
No, that is what my submission is, Lord. The only submission I have that she is not, in fact, the eyewitness. She has been made eyewitness, Lord. She being the wife of the deceased, she was not having inimical relations. She was living separately. She did not meet during the stay separately, Lord, because 125 matter is going on between them, and he was alcoholic person. He used to beat. She separated, Lord. She was living somewhere else.
Yeah.
And she did not used to come to his house. Even then, Lord, if presumed she was only a chance witness. This PW1. He says, Lord, कि वो 6 महीने से कभी उसके पास जाती आती नहीं, separate रहती है. Or on that day, how she reached at the place of incident?
You yourself are giving the answer that she is a chance witness.
Yes, yes.
Chance witness has stands on a higher.
Chance witness is made as a eyewitness, Lord. That is what my submission is.
Chance witness is far more important.
No, Lord, she is made eyewitness. That is what my submission is.
The chance witness का मतलब क्या है? That is not a planted witness.
Yeah.
कहीं ऐसे ही जा रहा था, अचानक देख लिया.
No,
chance witness.
She was having.
आप ही बोल रहे हो chance witness.
And she claimed herself she is living in the house of. उसने admit किया है कि मेरा उसका succession certificate था, and she was having a dispute with him. How can she be there at the place of incident at that particular time? Okay, Lord, even that. It clearly appears that she has been made eyewitness by prosecution.
You are arguing that she is a chance witness.
No, Lord, take it for granted. I said, even if she is only a chance witness.
The moment you say she is a chance witness, your entire case goes.
No, my lord. My case is based. The conviction of the trial.
She is not a planted witness.
Yes, my lord.
She is a chance witness.
I am a planted witness.
So she is a chance witness. Then you have to.
No, there was nothing like this. My submission right from beginning is that she was not eyewitness, in fact. That is the total submission, Lord, on this available.
Application seeking on behalf of the
Accused number 5.
accused
Harry.
number 5, Harry Woodson. The appellant, along with 4 others, were convicted and sentenced as follows. Question is, file an application seeking counsel in appeal contends that though PW1 has been narrated as a eyewitness, her statement cannot be accepted. That she arrived at the scene of offence after the incident took place. The same is narrated in para 20, 30 bulletin.
There are 20, 28 and 33. PW1.
And 32 of the
PW1.
Therefore, if the evidence of PW1 is to be achieved, he will be entitled not only for suspension of sentence but even acquittal. The state is disputed by the learned SVP. After hearing learned counsel, we do not find any ground. PW1 is eyewitness. He has narrated the manner in which the incident took place. He has seen the allegation made by her against the appellant Harry is to the effect that he stopped the vehicle of the deceased and made him to fall down. And thereafter, the other accused persons, namely Krishna Kumar,
Ballam, Krishna, Pappu
Ballam.
Deemer. Krishna Deemer.
Pappu Rajkumar alias Pappu, then
Malot,
Sachin alias Bomman, Rajkumar alias Pappu, and
Achu Thakur.
Achu Thakur
Urf Akshay Thakur. Alias Akshay Thakur.
committed the offence. And who threw that stone?
Malot, that was the deceased accused person, that is Rupesh.
And the accused Rupesh threw a stone boulder on the head of the deceased.
There is cement stone that is
Cement block. Thereafter, the accused Rupesh is said to have passed away during the trial. Would this being the contention, not fine that the record to disbelieve the statement of the eyewitness. The trial court has considered the manner in which the offence takes place. The statement relied upon by the opponent to the effect that the eyewitness arrived at the scene of offence after the crime was committed cannot be accepted. In fact, she arrived at the scene of offence even according to the appellant when the large number of people were standing. She has stated in her examination in chief that thereafter the deceased picked up his motorcycle and tried to run away and tried to escape on the motorcycle. It was the appellant, Harry, who stopped the motorcycle, made him to fall down, and the incident has occurred. Therefore, there is a clear evidence of PW1 so far as the appellant is concerned. We do not find that the statement of the eyewitnesses in the cross-examination has found any favor in the cross-examination. We do not find it.
Lordship, I am appearing for 10.3, Lordship, in the same matter. Lordship, I have just not filed the suspension, Lordship. The matter is connected with the same matter.
Why it is listed?
Lordship, the matter was
connected.
Yes, we take notice for this. I think.
Obliged.
बाकी का भी 10.2 भी admit करो, तो भी admit नहीं, तो भी admit. Yes.
सर इसको प्लीज पास ओवर में करें, पास ओवर.
In item number 12.1 and 12.2, my lord, objections are required to be filed. In item number 12, there is no IA for suspension.
12 admit. Point 1.
We will have to file objection.
The first time it's coming.
My lord.
Huh?
So IA was filed on 10/1/2020.
When you're filing the
2 weeks time.
weeks finally to file reply to
Obliged, Lordship.
point 2.
Obliged.
Kumar Rajak. Lordship, there is a IAF amendment in this appeal, my lord.
Amendment in criminal appeal.
Yes, my lord, there is an order dated 3/8/2022, my lords, may please to see that.
Carry out the corrections.
My lord, this honorable court direct, my lord.
Amendment. Allowed.
लॉर्डशिप, आई हैव ए रिक्वेस्ट लॉर्डशिप, इस केस में लॉर्डशिप अपीलेंट वाइफ ने एक मेंटेनेंस केस लगाया है लॉर्डशिप, जो फैमिली कोर्ट में 4 मार्च को लॉर्डशिप फाइनल ऑर्डर के लिए रखा हुआ है, और इसमें सेक्शन 24 का आवेदन है। तो मैं हम्बल रिक्वेस्ट ये कर रहा था कि इसको 4 तारीख के बाद के लिए रख लिया जाए लॉर्डशिप।
My problem is that, my lord, my learned friend is making request. I have no, though I am facing problem, financial crisis.
But he's saying that IA is going to be considered.
That fifth, my lord.
कॉपी निकाल जी जी लॉर्डशिप, सर्टिफाइड कॉपी लगानी पड़ेगी लॉर्डशिप, तो थोड़ा सा 2-3 दिन का समय दे दें। 4 तारीख के
4
बाद।
weeks at request of this.
My lord, 4 weeks is so long, my lord.
Maintenance.
I am praying for interim maintenance.
But he's saying it's already being considered by the.
Under proceeding of the 125 CRPC, my lord. And on that basis, he is praying for time, my lord. My application is under section 24 interim maintenance pendant, like, my lord, here. And the proceedings under section 125.
Of divorce, the London Trial Court has granted decree of judicial separation.
Separation, not divorce.
Against that order, both the parties have filed the appeal before the.
What happened in mediation?
Failed. वो क्रूएलिटी को तो माना है ट्रायल कोर्ट ने कि क्रूएलिटी की है, मगर वो 2 साल की बजाय 1 साल का पीरियड था. दैट्स व्हाई डिक्री ऑफ डिवोर्स नॉट बीन ग्रांटेड बाय द ट्रायल कोर्ट. नाउ आफ्टर पासिंग द डिक्री अबाउट 4 years have been passed.
Your Honor,
Now
please
the
to take
decree
this
of
matter as a
divorce
final
has been
hearing, my lord, after holy vacation, my lord.
We'll hear it now itself.
Yes, we are ready.
Please argue.
I am not ready, my lord. Your Honor, may please to take this matter after holy vacation, my lord. क्योंकि इनका interim
होली का
application.
vacation है क्या?
इतना सा इशू मिला, ट्रायल कोर्ट ने ये कहा क्रूएलिटी तो की है, मगर
After-
चूंकि 2
after
साल
a
की
week-
बजाय 1 साल के सेपरेशन में फाइल कर दी है. दैट्स व्हाई डिक्री ऑफ डिवोर्स कैन नॉट बी ग्रांटेड. इंस्टेड ऑफ दैट द डिक्री ऑफ जुडिशियल सेपरेशन हैज बीन ग्रांटेड. नाउ आफ्टर पासिंग द डिक्री, द एक्ट इटसेल्फ सेल्स के 1 साल हो जाता है जुडिशियल सेपरेशन की डिक्री को, तो डिवोर्स कैन बी ग्रांटेड. नाउ मोर देन 3 years हैज बीन पास्ड.
We will hear it and dispose it of.
Yes.
Get
Any
ready
fixed,
by
any
next day.
fixed, my learned friend.
Your Honor, please give
Any fixed
a
date.
short date, my lord, after a week.
Both councils.
13th,
Final argument. 4 weeks finally.
My lord.
my humble submission, any fixed week.
Any fixed date, my lord?
Yes, you get ready. That is more important than fixed date.
Paper-
आते हैं आर्गुमेंट किया तो वही बड़ी बात होगा.
Good evening.
My lord.
Yes.
Lord, Lordships had already issued notices to the respondents. There is the relief clause 3 is with regard to fixation of his.
Can grant this counsel.
Lord,
P18 is the, P19 is the document wherein the recommendation is already made, but no final order has been passed by the commissioner. So he will take the decision on this recommendation.
This petition has been filed challenging the validity of rule so and so. Presently, this instant application has been filed seeking to grant approval or fixation of this pay. Considering the IA is as good as hearing the main matter. Hence, we do not want.
That rule is with regard to counting of his previous services. That is in the rule number 3.
We are not going to.
The commissioner has not taken any decision on that. That is pending.
All matters that can wait, council.
But there's an IA for some further interim directions, my lord. My lord, challenges to the schedule provision, my lord, where 10,000 per day penalty for non-filing of return is there. My lords, my lord, were pleased, my lord, on 8th of July 22, my lord, to stay the demand, annexure P15. Now it's a consolidated order, my lord, demand plus suspension on that count. My lords, in similar cases, my lord, we have filed an order annexed to the IA at page 6. In subsequent cases, my lords have been pleased to say that since the suspension of mining operations has been issued in view of non-payment of the dues, therefore that also is under a stay, my lord. Yes, I am praying for further order only at page 6, my lord.
Both learned council. Stay has been granted of impugn order suspending the mining operations. Copy of one such order in WP 17701 or 22 dated 15/12/2022 has been produced. You have the submissions made, the application allowed. There shall be a stay of the
P15, this is a consolidated order. My lords earlier granted a demand stay.
impugn order dated 26/2020.
So far as suspension is concerned, authorities are saying कि आप वो लिखा के लाइए वहाँ से.
To the extent it suspends the mining operation.
Right.
Extended in the further order.
Eyes are awaited.
Why you await reply? You got interim order, no?
You hope they don't file a reply.
No, our understanding may be wrong, please tell us. They have a right to file a reply, they have a right not to file a reply.
Yes.
Both.
I don't think you can insist on that.
No.
Because we are finding orders saying,
was just an-
if you don't file reply, we'll do that, we'll do this. That's not correct. He need not file. That does not prevent us from considering your request.
Although the notice has been issued to the respondent on the IA, which is filed by me for the stay of the degree, my lord.
Decree for?
My lord, the girl has filed the case under section 13 of the Hindu Marriage Act. With regards to that, she has alleged that forcefully marriage has been done by the respondent, and the Y has filed the application under section 9 of the restoration of the conjugal right. So my application has been dismissed by the court below, my lord, and the application of the boy has been allowed.
Your application for?
13 of the Hindu Marriage Act for
divorce?
Yes, my lord.
Restitution has been ordered.
Yes, my lord. And the application which is filed by the boy, my lord, under section 9, restitution of the conjugal right, that has been allowed, my lord.
Appellant, though served, is unrepresented. Third appellant's counsel admit stay of the order dated where is the order, Mr.
My lord.
Don't even write that in your application for stay. कौन सा ऑर्डर है, कौन सा कोर्ट का?
मतलब तो same court consolidated order. That is, my lord, annexure A1, my lord. Annexure A1, page number 9.
So and so, passed by so and so until further order.
Great.
कारण हमारा अपॉइंटमेंट कैंसिल कर दिया, ज्वाइनिंग कैंसिल कर दी। मेरा निवेदन सिर्फ रिटर्न सभी लोग रिप्रेजेंट कर रहे हैं, इसमें रिटर्न में या तो ये फाइल कर दें कि कोई रूल्स या रेगुलेशन है या फिर मैं पेश करूँ? ये वन देखें लॉर्डशिप काइंडली।
What is your facts, counsel?
फैक्ट लॉर्डशिप ये है कि सर्किल बेस ऑफिसर के पद के लिए हमने अप्लाई किया था, उसमें सिलेक्शन हो गया और ड्यूली और अपॉइंटमेंट लेटर जारी करने के बाद ज्वाइनिंग लेटर के लिए बुलाया। ड्यूरिंग पेंडेंसी ऑफ वेरिफिकेशन डॉक्यूमेंट हमको ये बताएगा कि आपका सिविल स्कोर लो है, इस कारण सिविल स्कोर जो होता है आरबीआई के द्वारा डाली, तो वो हमारा 450 था, हमने वो भी बताया। अब उन्होंने E1 के द्वारा इस आधार पर पढ़ देता हूँ, विथ रेफरेंस टू एवं बी एडवाइज दैट यू हैव बीन फाउंड ineligible for appointment as circle based officer in SBI due सिविल रिपोर्ट। ये लोग सिर्फ कोई सिर्फ एडवर्टाइजमेंट जो P3 में दिया, परंतु इसमें कोई रेगुलेशन रूल्स वगैरह हमें नहीं बताया।
क्या रिपोर्ट है? एडवर्स डिफॉल्ट रिपोर्ट, सिविल क्या है ये?
ये सिविल जो होता है बैंक का रहता है, उसमें तो लोन ग्रांट करने के लिए देखा जाता है लोग से।
नहीं, क्या है वो? तुम्हारा डिफॉल्ट एडवर्स बोल रहा है ना?
हाँ, लोन हमारा लोन है, ये बात सही है, परंतु उसके कारण से हम डिप्राइव नहीं किया जा सकता अपॉइंटमेंट से।
आपने लोन लिया?
लोन लिया है दूसरे बैंक से, HDFC से।
कोई बात नहीं,
वो अलग एग्रीमेंट है।
डिफॉल्ट कर दिया?
यस।
अब बैंक का नौकरी चाहिए
तो नहीं, वो ठीक है, हम चुकाएंगे।
हम कुछ नहीं बोल रहे हैं, ऐसे पूछ रहे हैं
जी। वो डिफॉल्ट है
तो नौकरी देना है।
नौकरी, ये अपॉइंटमेंट हो गया हमारा,
तो आपका पगार वो लोन को जा सकता है अगर नौकरी
जी
दी।
जी बिल्कुल।
ऐसा करना है for the bank.
Yes, my lord.
Why don't you give him a job and recover the loan?
My lord, we will file reply in this matter, my lord.
नहीं, कुछ नहीं है इसमें।
गलती में भी ग्रांटेड थी, हम वहाँ को
Dismisses withdraw with liberty to pursue step.
Lord, I have been working as a guest teacher in law. Thereafter, on 2018, I have appeared in the direct recruitment of the middle school teacher under the reserve category for OBC for
Yes.
guest faculty teacher.
Yes.
Thereafter, I have cleared my examination. My scorecard certificate is made courtesy annexure P3, my lord.
Yes. Now what has happened?
Thereafter, my lord, they have not considered me for appointment, and after
Singh.
obtaining
My lord, this is second round of litigation. Earlier, it was disposed of by annexure P4 at pin number 24 with a direction to consider his candidature, my lord.
Yes.
And so accordingly, we have considered and passed the impugned order annexure P5 page 25. I will just read 2 lines. Third point down below. याचिका कर्ता के अंक page 25 down below.
Yes.
Third point. याचिका कर्ता के अंक उसके प्रवर्ग में अंतिम चयनित अभ्यर्थी के अंक से कम होने से याचिकाकर्ता को मेरिट क्रम में चयन की पात्रता नहीं है. So nobody who has received marks below him has been given appointment.
very interesting thing, Lord. Kindly see annexure P5. क्या कह रहे हैं ये कि याचिकाकर्ता श्री देवेंद्र कुमार सेन माध्यमिक शिक्षक हिंदी पात्रता परीक्षा 2008 में प्राप्तांक 94%, 94.73 ये हमारे परसेंट है। 150 अंक में यदि ये परसेंट है तो हमारे अंक 141 के ऊपर होंगे, 141, 141 पॉइंट कुछ। ये कहते हैं कि लास्ट जो कैंडिडेट जो सेलेक्ट हुआ है उसके अंक 120, 120.93 है केवल, और रैंक 190 बता रहे हैं।
आपका कितना है?
हमारे 141 होंगे। हमारे में इनने ये नहीं बताया कि हमारे मार्क्स कितने हैं। कैसा मिसलीडिंग annexure P5 काइंडली सी हाउ दे आर।
You are 141.
41.5 ऐसा कुछ होगा हमारे, यदि 94 पॉइंट।
कहाँ से आता है वो 141?
इसको कैलकुलेट करेंगे परसेंटेज के अनुसार, यदि मार्क्स निकालेंगे तो आएगा।
आपका कैलकुलेशन?
जी, मेरा कैलकुलेशन।
Government, what do you think?
Normally, everything is available on the website, my lord. I'll produce it on it.
Take notice, let us.
My lord.
He takes notice for after 4 weeks. He's saying his calculation becomes more.
My lord.
Take it up.
My lord. So in this professional examination board should have been made a party. Nevertheless, I'll seek instructions.
Yes.
This is the appeal, my lord, against the order filed by the learned single judge. The petitioners who are holding the post of upper division teacher, one advertisement has been issued by the authority for, my lord, filling up the post of BAC and CAC on deputation, my lord. There was a policy, a specific policy, my lord, for preparation of my lord, merit list, and that provides, my lord, please. My lord. The policy provides, my lord, the separate merit list of upper division teacher and Madhyamik Shikshak would be prepared. The authority has issued consolidated, my lord, merit list. Therefore, my lord, we filed earlier a petition that was disposed of by directing the collector to take a decision. We submitted, my lord, application before the collector, but he failed to, my lord, take a decision within time, and he issued the, my lord, impugn orders, by which, my lord, he issued the select list. Therefore, my lord, we challenge the select list, my lord, by the petition. By taking a specific, my lord, ground that the authority cannot, my lord, issue the consolidated merit list as per the, my lord, provisions of policy. And other districts are concerned, they have issued the, my lord, separate merit list of, my lord, seniority list of UDT as well as the, my lord, Madhyamik Shikshak. Those orders have been filed. And by claiming parity as well as the, my lord, for compliance of provision of policy, I have filed writ petition. My writ petition has been dismissed by saying that, my lord, I have failed to assail the order of collector which passed, my lord, in pursuance of earlier writ petition. As well as, my lord, the
that is only one ground.
Ji.
But they say for MS, the seniority is as per date of appointment.
Yes,
and for others, it is subject wise.
My lord, the seniority of my lord, MS is, my lord, counted from their date of absorption. That is 2018.
Correct.
All the, my lord, Madhyamik Shikshak who absorbed, my lord, from the Adhyapak Samvar in Madhyamik Shikshak, my lord. That is, my lord, educational school education service. And after absorbing the, my lord, their services, the appointment should be counted from that date. This is the, my lord, circular as well as the rule.
Yes.
And other districts have counted their service with effect from, my lord, 2018.
Yes.
But the Chhatarpur district, in which, my lord, petitioners are concerned, in this district, my lord, they have counted, my lord, separate date of appointment.
Yes, Government.
We filed our return in the writ petition. In that, we have categorically pleaded two aspects. One is that the merit list which has been prepared, it's been prepared as per the policy only. Now, my lords, may come to paragraph number 5 of my writ.
He's saying there's a deviation between districts. One district is following one policy, you are following another.
I would seek instructions on that, because on that aspect my return is silent.
Considered by the learned single judge.
My lords, because it was silent and it was not contending, so it was not considered by the learned single judge as to whether there is discrepancy between the districts.
Whether it is right or wrong, we don't know. But you cannot adopt different standards in different districts.
I vote on to that. I'll seek instructions on that, because that was not the pleadings, in fact, before the writ court.
No,
and that has not been considered.
So this was the specific pleading, my lord. Annexure P12 are the orders of other districts. This is specific pleading.
I'll seek instructions.
Here takes notice for.
That would be
1 to 4.
All for them.
All respondents.
Even assuming there is some finding by the collector,
My
apparently that has missed the attention of the learned single judge.
my lord,
Single judge says representation, rejection is not challenged, so.
not challenged.
Actually, if it's not challenged, that means the original impugned order will
Prevail.
sustain.
Sustain.
So that can't be a ground to dismiss a writ petition.
But then what the learned single judges said that he should have challenged that order because that is not going against him. That has attained
A
finality.
technical ground.
It's a technical ground.
You may get material.
My lord,
4
it's
weeks.
the default of payment of court fees.
On I have filed, my lord, because cause of action is same, my lord. I am relying upon one judgment, my lord.
अरे कोर्ट फी के लिए क्या जजमेंट कितना है कोर्ट फी
250 rupees per
अरे दे
I'll pay.
दे दो
I'll pay.
रिजेक्ट अप्लाई बाय नेक्स्ट
हाँ भाई लोग।
कोर्ट फी
There is your judgment because my lord, is number of petitioners are there and cause of action is
will
there.
not waste time on all that.
I'll pay, my lord.
Yes.
हाँ भाई।
Or unless you are not sure that notice will issue.
No, no,
Dismiss होने वाला है क्यों
I'll pay, my lord. Therefore, my lord, I have filed that. I'll pay.
all right.
हाँ भाई लोग।
Yes.
This is a writ appeal prepared by the Municipal Corporation against the judgment passed by the learned single judge. The learned single judge has granted a compassionate appointment along with the 50% of the back wages. While I am not agreed by the direction for the grant of compassionate appointment that has already been granted to the respondent, but I am agreed by the grant of the direction for payment of the 50% at back wages.
तो 100% करना था.
Well, with that regard, my submission is, my lord, there has to be specific pleading from the employee that he was not gainfully employed during that period in which he has been granted a back wages.
Suppose he proves it, will you give 100%?
Well, that then I will encounter.
Suppose he'll bring material to say he was not employed. Will you give 100%?
Well,
If
then
he say
I-
yes, we'll record it and stay.
Well, in that case, then I have to lead the evidence that he was not gainfully employed. Well, that was not even the prayer in the writ petition also.
Right.
I am relying on these two judgments.
When he applied for this compassionate appointment,
Well, what happened in this case? Well, in 2015, the compassionate appointment was granted by the commissioner to the respondent. In 2017, after 2 years, it was cancelled because there was an objection from the audit department. Thereafter, it was cancelled, madam.
so you are not granted salary for the period that he has worked.
So that has been granted, madam, along with the compassionate appointment. I am only out to the extent of 50% of the grant of salary till the date of a statement that I am challenging, madam. Since there is no specific pleading, the onus is on the employee to demonstrate that he was not gainfully employed during that period, madam. Until unless that is not made, the back wages cannot be granted, madam.
Yes, what is it?
My lord, my humble submission is that this honorable single judge has observed in the page number 13, my lord, in para number 11. May I read the matter? It is resolved this petition is allowed the order dated 3/6.
Where is the reason for it?
That is further, my lord. The respondent corporation is directed to instead the petitioner will be entitled to the salary for period for which she has worked, and since cancellation of her appointment was illegal, 50% of the salary from 3/6/2016 till date she is restrained. So,
Here they say that it is denying her salary for the period she has worked.
Well, that has been complied with, madam. We have granted compassionate appointment along the period. I am just changing the last line, my lord, was illegal. 50% of salary from 3/6/2017 till the date of reinstatement. My lord, she has worked from 2015 to 17.
Please read the whole sentence.
My lord. For the salary for which she has worked. My lord, she has worked.
Read the full sentence, mister.
And since cancellation of her appointment was illegal, 50% of salary.
Read the full sentence. Do you know where a sentence begins?
My lord. The petitioner would be entitled to the salary for the period for which she has worked, and since cancellation of her appointment was illegal, 50% of the salary from 3/6/2017 till the date she is reinstated.
When did she work?
She worked from 18/12/2015 to 2015
to
3/6/2017. And after on 3/6/2017, her appointment was cancelled, madam.
When did you reinstate her?
She has been reinstated after this judgment was passed, madam.
When did you reinstate?
I don't have the exact date. After the judgment was passed,
This is November 22.
well, immediately she was reinstated, my lord, and the salary was paid for the period she was lost.
Now, between 15 to 17, have you paid the salary?
Yes.
When you paid it?
My lord, along with the compassion appointment when it was granted, that was paid, my lord.
So how you withheld salary for 2 years and took work from her? She admittedly worked from 15 to 17.
17.
You are not given salary.
Initially, that was not granted, my lord.
Either way, for 2 years you did not give, na? So from date of cancellation till date of reinstatement, that 50% has been awarded.
Yes, yes.
This is a fit case where you should have imposed heavy cost on you. You can employ a person without giving salary. And out of your own interpretation, what is said by the learned single judge, your interpretation of law you have terminated.
No, my lord, there was an objection from the government audit department, my lord.
So what?
Initially, my lord, we
Therefore, the court has said 50%. It should have given 100%.
My lord, even with the case, we have supported the case of the petitioner, my lord, and the writ petition before the
Which
single
is not
judge.
gainful, does not arise counsel. Facts are different.
But my lord, I am relying on the judgment of this Honorable Apex Court, my lord. My lord, this is 2013, Volume 10, 324.
Para?
Page 356, para 38.2. Page 356, my lord.
Yes.
38.2. The aforesaid rule is subject to the rider that while deciding the issue of back wages, the adjudicating authority or the court may take into the consideration the length of the service and the employee workman, the nature of the misconduct, if any, found proved against the employee workman, the financial condition of the employer, and similar other factors. Ordinarily, an employer or the workman whose service have been terminated, who is desirous of getting back wages, is required to either plead or at least make a statement before the adjudicating authority or the court for the first instance that he and she was not gainfully employed or was employed in lesser wages. If the employee wants to avoid payment of the back wages, then he has to plead that it also leads congent evidence to prove that the employee workman was gainfully employed and was getting wages equally to the wages he or she was drawing prior to the termination of the service. This is so because it is settled law that the burden of the proof of existence of a particular fact lies on the person who makes a positive argument about his existence. It is always easier to prove a positive fact than prove a negative fact. Therefore, once the employee shows that he was not employed, the onus on the employer to specifically plead and prove that the employee was gainfully employed or was getting at the same substantial similar employment. I'm relying on another judgment.
Yes.
This is 2018, Volume 18, SCC 299.
Here also please read 38.3. How does it start?
Ordinary an employee or a workman.
Means what?
Well, the next judgment.
Ordinarily, this is not the rule.
Well, now the judgment I'm relying on. Para 12 of the judgment, Madam. May I read, Madam? Para 12. It is necessary for the workman in such cases to plead and prove with the aid of evidence that after his dismissal from the service, he was not gainfully employed anywhere and had no earning to maintain himself and his family. The employer is also entitled to prove it otherwise against the employee, namely that the employee was gainfully employed during the relevant period, and hence not entitled to claim the back wages. Initial burden is, however, on the employee. This is what I'm relying on. The initial burden is on him to prove that he was not gainfully employed. Then I will counter his claim.
So you're relying on this judgment?
No.
Huh? Shall we apply it? Please read para 18.
However, having regard to all the facts and circumstances of the case, such as period and money spent in litigation by deceased workman and on his death of his legal representative, coupled with the fact that the workman's pension has been since expired, we find it just in proper interest of justice to award respondent 50% of total back wages. In this case, they have granted it, but I'm relying on.
Follow the same thing.
But there has to be specific period that cannot be denied in the light of both the judgments that he was not gainfully employed.
First judgment is ordinarily. This judgment, they themselves are granted 50%.
But they have observed so, my lord, that it has the onus is on him.
We'll also observe it, but we'll grant 50%.
My lord, that was not the clear also in this petition, my lord.
Maybe. It's a writ court. Can mold the prayers.
And my lord, I show my bona fide, my lord, because in 2015 we have granted the compassion appointment, my lord, initially. It was only cancelled when there was an objection from the audit department. Even in the writ petition, my lord, we have supported the case of the petition for the grant of compassionate appointment.
So, le lo 50%.
Hello, I am the Municipal Corporation. We are one of the
What can we do?
same department.
You're also part of the government. You're relying on a judgment, we're relying on the same thing to decide.
Well, I'm relying on the observation which has been made, not on the conclusion what was there in the.
Follow the observation as well as the findings.
Lord, I'll rely on the observation, my lord, that may be.
Rely on what is there. Discussion. Yes.
I'm making a humble prayer that the order of transfer that has been passed in 2019 and executed by the appellant required, and the state government may be extended liberty to pass fresh transfer order if required. My lord, the fact of the case are like this, my lord. On 1/3/2019, on the ground of administrative exigency, the appellant was transferred.
So you were transferred in
2019.
Ah.
There was a.
Then now it is cancelled.
Thereafter, in 2019 itself, on the 7/3/2019, my transfer order has been cancelled. That order was assailed by the appellant before this honorable court in writ petition. The honorable court was pleased to grant a stay in favor of the appellant. The stay continued till the passing of final order in the writ petition. And by the single judge has observed that since 2015, 15/3/2019, the appellant is working on the transferred post.
4 years you have worked.
I am not saying that I should not be transferred. The reason on which I have been transferred is administrative exigency. Till after 4 years, what I have submitted, my lord, that subsistent note exigency. Now, my lord, my submission before this honorable court is that the state government may pass fresh transfer order in my case. That's all. Nothing more than that.
Let them do whatever they want. Why should we say all that?
The reason being, my lord, since they are what by this order, my lord, what will happen, my lord, that the order passed in 2019 will be executed now in 2023.
That's right.
The reason for if my
That's
lord,
right. That will stand revived now.
Yes, my lord, but the order that has been executed, the transfer order that has been executed is cancelled subsequently by the order of.
So you have to go back then.
Hello?
You have to go back then.
Yes, my lord. As per the transfer order, I have to go back. If the order is
so go back.
But since the order that has been upheld by the London Single Bench is annexure P1, that this is passed after my joining at the transfer place.
That's all right. Either way, it is spent itself now.
since 4 years I have been working over there, my lord, and
Tell it, okay.
there are there
So assume it's a fresh transfer order. We'll clarify that. We'll say it is in view of the stay order being granted, it is deemed to be a transfer order.
The place from where I have been transferred and reverted back is not vacant at present.
That is a secondary problem. They'll vacate it.
No
Moment
such
you go,
no transfer order in respect of coordinator has been passed.
Yeah, you are clinging on to something which does not exist. It's over now. You have succeeded 4 years. Or kya hona hai?
Sir, I'm not making that the entire proceeding should be filed. I'm making simple prayer that they may grasp fresh transfer order, posting me anywhere else.
Why should we say all that? We are
Because
not running the government.
Because after this order passed by the London Single Bench, my lord, the order will get itself effective.
So what is your problem?
I will be transferred.
Therefore, that order is deemed to be a fresh transfer order. ऐसा बोल देंगे. You are only saying no. Let them pass any fresh order.
No, my lord, I'm.
So यही fresh order है.
In case a fresh order is passed.
Not नहीं, यही fresh order है.
Then I may be. In case a fresh transfer order is passed.
Again, you will file one writ.
No. I'll have an opportunity to represent before the authorities explaining my reasons.
This is only a fresh transfer order.
Only 6 years have been left for the petition.
No, they are all different grounds now.
Since it is an
Since the transfer order, it has 4 years you have enjoyed an interim order. Everything goes. See,
in fact,
it is for them. वो करना है तो करेंगे, नहीं तो we cannot direct them to do.
Will be the order that has been passed in 2019 will be given effect.
Yeah. So what?
That too when the appellant has complied with the transfer order that has been passed.
You are not complied. You got to stay.
Yes, no, I have complied. I have joined at the transfer place. I gave joining and I joined at the transfer place. The interim order was given to for permitting me to
not to
work on the transfer place.
Yes. Yes.
It's a case, Mother. The certain land was purchased by the appellant is a society registered under the provisions of Madhya Pradesh Cooperative Societies Act 1960. Now the society had purchased some land through two separate sale deeds executed on 22/5/1962. There were two registered sale deeds in respect of Khasra number 225 and 226. Those were executed on 22/5/1962. The land was got diverted in the name of the society because it was purchased for the purposes of constructing residential premises. And the diversion was ordered by order dated 21/9/1974 in favor of the society. Now subsequently the society got a plan, the residential plan approved from the Department of Town and Country Planning, and the approval was granted on 26/7/1972. In the meanwhile, a notification was issued for acquisition of the certain land, including one of these Khasra numbers were also included in that notification under Section 4 of the Land Acquisition Act, Old Act. And that notification was issued, the preliminary notice was issued on 29/10/1962 under Section 4, and under Section 6, it was 13/12/1962.
Yes.
But now the acquisition proceedings had taken place. However, neither we were paid any compensation nor the possession was ever taken from us. A person whose land was also acquired under the same notification, he filed a civil suit challenging the acquisition proceedings.
Yes.
In the civil suit, the judgment and decree was passed declaring the acquisition proceedings as null and void, and it was declared that the land stood released in favor of the landowner.
Yes.
Now, subsequently, this land was acquired for the industries department of the state government. The industries department subsequently surrendered this land in favor of the revenue department, saying that they
acquired by?
It was acquired for the industries department for establishment of certain industries.
No, earlier the land was already acquired.
No, it was acquired through that's what the notification of
Under 4 and 6.
4 and 6, no, that's there. That notification was issued on 29/10/1962.
Yes.
And 6 notification was 13/12/1962.
Yeah.
This was subsequent to we had purchased the land.
Yes.
Our sale deeds were executed prior to that.
Yes. So you are the landowner.
We are the landowner.
So you lost the land in the acquisition.
This is what that neither the compensation of the land was paid to us nor the possession of the land was taken over from us.
Okay.
Now, subsequently, the industries department handed over this land, surrendered this land to the revenue department on 4/4/2009, saying that they are not in need of the land, and therefore the land was surrendered back to the revenue department. Now, after the land was surrendered to the revenue department, a notice under section 250 was issued to the society, asking to the persons the members of the society who had constructed the houses on the land in question. They were issued notices under section 250 for vacating the land.
Yes.
Those notices were challenged before this honorable court and writ petition. And if I can draw the attention of my lords to page 101, the honorable court passed an order. My lords may kindly refer to annexure P13. My lords. Starts from page 94.
Yes.
Now the court directed, my lord, when the notices were challenged, my lords may have a look on page 97 of the order passed by this honorable.
Yes.
The court said, my lord, looking to the facts and circumstances of the case, this petition is disposed of by giving a direction to Tehsildar Nazul Govindpura Bhopal that he may take note of the judgment of the civil court dated 25/1/1982, wherein the notification under section 4 of the Land Acquisition Act of the land mentioned in the judgment has been declared to be null and void and ineffective, and thereafter any order may be passed. Needless to say that if the judgment of the civil court has become final, due weightage should be given to the same, because the state government was party in the civil suit and the said judgment is binding on it. Till then, the possession of the members of the society as well as society over the land may not be taken. The society may also file a detailed submission application before the tehsil. So, one of the court took
all wrong orders. How can a civil court entertain this?
The question would be
basic fundamentals, and the same mistake High Court also commits.
The question,
that was the decree is null and void.
The question,
what is all this happening here?
This judgment and decree was never challenged.
The council, it is a void decree. It need not be challenged. It is void. It need not be challenged. Not a voidable decree.
For that, my submission is, my lords.
No, that's not acceptable. Any other ground we have?
Then, my lords may please see, even my lord ignoring for this decree for a minute. My lords may see that
it is not for a minute. Forever we have to ignore it.
But I'll
The trial court gets a decree to set aside acquisition.
That is there. Now, my lords may please see section 24 of the Land Acquisition Act.
Award has been passed.
Yes.
You have received the award?
No, we have not received.
Why you did not receive it?
That has not been paid to us. My lords may please see. There's a
award has been deposited.
It has not been.
Where is the finding on that?
Well, that the court has said, my lords may kindly see. There is a very specific pleading by us in.
Maybe where is the finding based on record?
The court says, my lord, that the erstwhile owner, because the mutation was not carried out. Court says, my lord, that since mutation was not carried out in the name of the society, and therefore, my lord, the award could not have been paid to the society.
Which para?
My lord, kindly see.
25.
Para 25, my lord. My lords may kindly see paragraph 24 and 25. Paragraph 24, my lord.
Where is the payment of compensation to the erstwhile owners at least?
Erstwhile owner has also not been paid. Erstwhile owner, in fact, informed them that this land has been sold by the erstwhile owner.
So award was received by him.
No, he did not receive award.
Then where is, what is this at 24, 25?
My lord, 24, 25 says, my lords may please see, page 18, my lords. Page 18, my lords, at the top, my lord, the averment made in paragraph number 7 of the return are important in as much as despite execution of sale deed, the erstwhile owner's name continued to be recorded in the revenue record. As to why the petitioner did not make any effort to get its name mutated in the record is an unexplained issue.
Correct.
So since our name was not followed, the court has said since our name was not recorded there. Now, but we had taken a very specific plea that the erstwhile owner was also not paid the award.
Have you made him a party?
Erstwhile owner is not a party.
Then why you did not make him a party? Counsel, this whole thing is a big mess. Basic fundamentals of law has not been even adverted to by any of these courts. See, the question of here, section 17 has been invoked.
Yes.
So immediately you lose possession.
No, that is not.
In law.
No, no. Section 17 says, my lord, that section 17 only prevents, my lord, certain formalities to be completed before acquisition. And, my lord, the possession can be taken by the, it enables the collector to take possession, my lord, within 15 days. Can we see, my lord? It's section 17. It does not, my lord, say that the possession automatically vests in the government. It does not say that. For that purpose also, one of the possession is required to be taken, but the only thing that the certain formalities which are otherwise required to be completed, those are not required to be completed.
Is that your ground of challenge?
My ground of challenge is that section 24 in view of the new act.
24 does not come in it.
Well, my submission, my submission is this, that in view of the provisions of section 24, because neither the award amount is paid nor the possession is taken over.
Land displays the name of the erstwhile owner, given as on date.
No, subsequently our name was put.
If at all you are going to challenge it, they should be a party in every proceeding. Number one. Number two, possession in terms of 4 and 17 would appear to have been taken from the records from you. Whether it is de facto or de novo or de jure is a different matter. This is the acquisition of the year 1962.
2 months.
Award has been passed. Payments have been received. As far as we are concerned, matter ends. Number two, if that public purpose for that acquisition in the year 1962 has been diverted for another public purpose,
we are not into
the year 2000, whatever it is,
we are not on that.
You cannot challenge.
We are not on that.
Correct. So you cannot challenge now saying award is not deposited. Unless the owner is also a party to it. He must come and say, you cannot file a petition and say, show me the records. Bring him to the court. Let him answer. Suppose, for a hypothetical situation, suppose he has taken the amount and gone. Then the entire petition fails.
That is absolutely correct, but
so that is why you are deliberately not making him a party.
No, it's not, Malod. There is a very specific.
आपको क्या फर्क पड़ता है उसको पार्टी बनाना? He is your vendor, na?
But they have sold that.
What is the problem? You have paid him consideration.
Yes, sir.
Then what's the difficulty in making him respondent? Difficulty is this, because he has taken compensation.
Malod, he has, in fact, we have taken a Malod. Kindly see, Malod, the pleadings which we have.
So you may say 101 things. You are bound to say that to save yourself. If you make him a party, you would have asked him. No, this is the lost cause. Firstly, on facts. Secondly, on law, we are shocked how these things happen. A civil suit degree to quash an acquisition. And the High Court passes an order on that.
Further,
Either way, that's not the same property, no? That's the same property.
that no, that suit was in respect of a different.
That fundamentals of law council. क्या हो रहा है ये?
May I some? Actually,
does anybody even have one whiff of land acquisition law? How a suit can be filed, counsel?
that was that jurisdiction.
It is being affirmed and affirmed and affirmed. The decree is void. There are hundreds of Supreme Court judgments on that. You don't have to go to a court to declare its validity. That goes. That's a different matter. Then as far as you are concerned, since 4 and 17 have been invoked, thereafter possession has been taken, you will not have any locus to question it at all.
May I make a respectful submission?
If at all, the only ground for you will be on delay. That when section 17 has been invoked and public purpose is not gone ahead, then it vitiates. It becomes a fraud on power. But that is not your case. Secondly, they have diverted the public purpose. They are entitled to divert it.
That can be done.
That can be.
If
that can be done, then what remains?
My submission is this, my lords, my submission is this, my lord. Firstly, though they had invoked section 17, but possession was never taken. If the possession was taken over, my lord, there was no occasion to issue notices to us in the year 2012 to get us evicted from that land. Firstly. Secondly, my lord, section 17, in my humble submission, my lord, section 17 does not say that the possession is automatically vested in the government.
Yes.
That formality of taking over the possession is yet to be completed. It's, my lord, it only says, my lords.
Even then, how does that help you?
My lord, that helps me for the regions, my lord, that admittedly the possession was not taken over.
All right.
And it's not that, my lord, the state is aware my order of divergence are passed in the year 1974. And there the society, it is the name of the society. I filed that order of divergence.
Read 17(1).
My lords. This is not in cases of urgency, whenever the appropriate government so direct the collector, though no such award has been made, may on the expiration of 15 days from the publication of the notice mentioned in section 9, subsection 1, take possession of any land needed for a public purpose. Such land shall thereupon vest absolutely in the government, free from all encumbrance. So it only enables the collector, my lord, to take the possession on expiration of 15 days time. And it is, my lord, the collector may. So there is no automatic vesting, my lord. There is no automatic taking over of possession. The possession is yet to be taken. So my humble submission is this, my lord, that, and here is a case where
at the most your argument de facto possession.
Yes.
It may be a de jure possession that they have taken. So what is the purpose in invoking 17?
17 emergency.
For emergency clause, you can't wait for 9 days.
But my lords should kindly see that section 17 is invoked. In 2011, the land is surrendered back to the revenue department. The revenue department issues the notices.
Surrendered by whom?
Well, surrendered by the industries department, for whom this land was acquired. So my submission is this, my lord, that as far as section 24 is concerned, my lord, the acquisition got, my lord, lapsed under section 24. And if I can submit with my lordship, my lord, though the...
How 24 you can invoke?
My lords, please see section 24, my lords.
Welcome.
Yes. My lord, this 24 is titled, my lord, land acquisition process under so and so shall be deemed to have lapsed in certain cases. Notwithstanding anything contained in this act, in any case, the land of acquisition proceeding initiated under the Land Acquisition Act 1894, where no award under Section 18 of the said Land Acquisition Act has been made, then all the provisions of this act relating to the determination of the compensation shall apply, or where an award under Section 11 has been made, then such proceedings shall continue under the provisions of the said Land Acquisition Act, as if the said act has not been repealed. Notwithstanding anything contained, my lord, subsection 2. Notwithstanding anything contained in subsection 1, in case of land acquisition proceeding initiated under the Land Acquisition Act 1894, when an award under the said section 11 has been made 5 years or more prior to the commencement of this act, but the physical possession of the land has not been taken or the compensation has not been paid, the said proceeding shall be deemed to have lapsed, and the appropriate government, if so chooses, shall initiate the proceedings of such land acquisition afresh in accordance with the provisions of this act. Now, though it says or, but the Supreme Court has said no, this or has to be read as and. So both these things are, if in for lapsing, both things are not required to be complied with. Yeah. But here in this case, my case is this: neither the possession is taken over, nor the amount of compensation is paid.
Where is the finding on that?
The finding is, that the name was not recorded. That has not been answered clearly.
So how have you proved? Let's assume for argument's sake you're coming under 2. How you prove it?
We have said, that the amount, the compensation has not been paid to us.
See, 101 thing, mister. How do you prove it?
The
admittedly, you are a purchaser.
Well,
your name is not on the records as on the publication of 417 and 6. You can never complain about it. You can only go for apportionment. Because the award is passed and it will be deposited. Even in subsection 2, even if the award is not paid, is different. If they deposit in the civil court, then they satisfy that liability. So you are saying you have not got the award. You will never get the award because you are not there on the record.
By pleading,
so where is your finding on that?
My submission is this, that in my petition, I very specifically firstly said, that the compensation was not paid. Secondly,
well, again, you are repeating the same thing. You may say everything. There has to be material to support whatever your contentions are. Compensation is to be paid to whom?
Is to be to the recorded
to the notified owner.
Yes.
Are you the notified owner?
I was not.
You are not. So they have given it, let us say for argument's sake, to the notified owner. Or they have not given it to him. The state should answer it, or your vendor must answer it. You have deliberately not made the vendor a party.
Said in my petition very specifically that the vendor has,
you say something, no. we'll also say something.
I know. What I am trying to say.
Counsel, you must come clean to the court.
In fact, it's
call your vendor, make him a respondent. We'll ask him whether he has received compensation or not. Finished, matter ends.
If my lord permits, we'll make
Why should we do it? We are not running a law school over here.
My lords, may please see. We have said, that the vendor has informed.
Short counsel.
The vendor has informed the land acquisition officer that this land has been sold by me.
Help you, counsel. He is entitled to receive the award because he is the notified owner.
Yes. Yes, he is the recorded landowner.
He is entitled to receive it. Even if he has sold, he has not sold, he is entitled to receive it. Even if entire compensation is paid to him, you can have no grievance. You can only seek for apportionment.
Now, my lord, my humble submission is this: that, my lord, considering that he should have been made as a respondent, so that he would have come and said, my lord, whatever is the position. But we had made a very specific plea that the compensation was never offered. So the state government also does not say, there has to be a specific plea from them
you cannot bring some blank writ petition and expect all the records to be summoned to the court. Aisa chalta hai kya?
It was not blank, my lord. We have said that it is not paid, and we have simultaneously said
you are the plaintiff. You must prove your case. Burden is on you.
Now accept, my lord, to implead him as a party, otherwise I have no other means to show.
All that is all just blank statements. Nothing, no material at all. You're relying on some decree which is void. And subsequent orders, God alone knows how these orders are passed.
And my submission is this, my lord, that there is neither any, there is no denial.
Read para 7 of their objection.
Para 7, man.
Of the objections filed by the state.
One. As far as order of Learned Board of Revenue is concerned, the Learned Board of Revenue, white order dated 17/1/2014, specifically noted that as applicant was filed, application was filed under the provisions of section 32, that be 115/116 MPLRC, before the additional Tehsildar Govindpura Circle, Bhopal, that the petitioner society had purchased agricultural land at village Semar Kala White registered sale deed dated 1/5/1962, measuring 11 acres 98 decimal, and thereafter White sale deed dated 22/5/1962, a parcel of the land measuring 6 acres 50 decimal. According to the petitioner, on obtaining copies of the Khasra, petitioner came to know of the fact that the name of the state of MP is recorded as Bhumi Swami on the said land, and before recording such name, no intimation was given to the petitioner. In this regard, it is respectfully submitted that notification under section 4(1), that is section 17 of the Act, was published on 23/11/1962, and thereafter under section 5 of the Act was published 11/1/1963. Thereafter, a general notice under section 9(3) of the Act was published and affixed on conspicuous places. Thereafter, notices were also issued to all the persons interested in the land under acquisition. 30 out of 35 claimants of village Samarkala claimed compensation. It is not in dispute that the petitioner had purchased land from Har Prasad Keval Singh Badri, Prasad and Jagannath, all sons of Kaluram, who had referred their objections before the land acquisition officer, as can be seen from the narration of paragraph 7 of the award dated so and so. Similarly, another piece of land was purchased from Mohanlal, son of Puran, whose names are mentioned in paragraph 7 of the award. A bare perusal of the document annexure P1 and P2 will demonstrate that though the petitioner society had purchased the land in question, but had not obtained mutation in their name as on the date of issuance of notification under section 4, read with section 17 of the Act of 1894. As a result, notices were issued to the original owner of the land, who had appeared and had submitted their claims for raising objections regarding maintainability of the land acquisition proceeding. Thus, the society was stopped from raising any objection subsequently. In fact, it is petitioner's own admission that they sought mutation in the revenue record only in the year 1967-68. Thus, the land acquisition owner officer was justified in sending notices under section 9(3) of the Act to the persons whose names were mentioned in the revenue record. The additional Tehsildar, upon direction of the Honorable High Court in WP number so and so, considered the matter on record and reached to conclusion that the petitioners are not entitled to the benefit of judgment and decree dated 25/1/1982, as it was only specific Khasra number of Sardar Machi Singh who was a plaintiff before the trial court. Further, in the light of the decision of the Honorable High Court in the case of Pashu Chikitsa Vibhag Sehkari Grah so and so, petitioner is not entitled to get the relief.
So 9(3) also was issued.
9(3) was also issued.
Then what case you have?
Mano, the case is, Mano, that kindly see in this entire para, they do not say that the compensation has been paid either to the original.
He has contested the award. It's part of the award. They produced the award also, P7, Part 7. The petitioner himself. You have produced the award.
Well, we have filed the award.
What is the award? So kindly read it.
Page 36 of the petition. It starts from page 36. Read.
Who is your vendor?
My vendor is Manoj. I'll just. हाँ. My lord, my lord, it is the Har Prasad, Keval Singh, Har Prasad, Badri Prasad, and Jagannath. Har Prasad, Keval Singh, Badri Prasad, and Jagannath.
They even objected in the award. They have participated in the award proceedings. Para 7.
Their names are my lord on page.
अरे है ना वहाँ पे हर प्रसाद
जी 58 पे है सर page. Names
So
are.
they have contested the proceeding.
My lord.
Then
But one of the compensation is not paid.
how you can missing that link there? They are the notified owners. They have participated in the.
That proceeding.
They have taken the award. Correct. Award has been paid to them.
No. Not.
Again, you are telling. Anyway, as far as we understand, they have taken the award. As far as you are concerned, if you have purchased the land from him and he has taken the award, the list is not between you and the state, it is between you and him. According to you, you have purchased the land for valuable consideration. So anything happens to the land, you are entitled for the fruits of that.
Yes, if is.
Yeah, this man has even taken the award. So you must contest the award. You should have stopped disbursement. One thing is you wake up only 5 years later. So what is the date of the award? 63.
63.
Your mutation goes in 67.
Yes.
Let us assume there is no mutation, but you are still a registered owner. So your grievance is against whom? Against the man who has wrongly received the award. You should have got the award.
Absolutely correct. But provided he has received the award.
So you can't come and say all these. That's why our initial observation is he should have come here. Should have brought him to the court and said, look here, he has not received the award. What do you say? Then he would have said, I have received, I have not received. That you very conveniently avoided. The only grievance is, if the land is acquired, I am the owner, give me the award. How the government can give double award? And it is not that he has not participated. 93 is also issued, he is also part of the proceedings. Backdoor entry.
My respectful submission is this, my lord, that what my lords have said, that is absolutely correct, that there can't be two awards. Two persons cannot receive the compensation for the same land. And I could have raised a grievance against the previous owner, my lord, or the seller. If he had received that amount, then my lord, I cannot make any complaint against the government.
Argue all that here. You are not entitled to find out all that here. You should have procured the record. You should have got the information from the government to whom you have given the award. How much money you have given? It is your land, na? Are you not entitled to ask these questions? Are you not entitled to challenge the award? Award has passed in 62 or 63. 67 you go for mutation. Where is the answer to all that? Not a confusion on fundamentals of acquisition law. That is why you are getting into this problem. You just look at it plainly and cleanly. You have purchased the land. Your name is not entered. Let us assume it is not entered. You are still entitled for possession. You can still set up a claim before the collector. You can still say that, all right, he is a notified owner. That is fine. But I have purchased the land. I am the owner. Then collector will issue notice to him. You will hear both of you. You produce the sale deed, award will go on your name. Right? Not necessary that you have to get your names mutated. Not required. If you have a registered sale deed, you can still set up your claim. That you have not done. And you are relying on some decree obtained challenging acquisition.
What my submission is. As
I have not got compensation. I want compensation.
What I want to submit, my lord, that if, assuming, my lord, for a minute, that the previous owner who has sold me the land, if he does not, because he has no reason to take any interest now, because whatever he had to get, he has got it from me. Now, if he doesn't take any interest, except to implead him as a party, my lord, that is correct, that I should have impleaded him as a party. But otherwise, my lord, what recourse I can have except to implead him as a party?
So you can't ask legal advice from us.
No, I'm not, my lord. I'm sorry, my lord. I'm very sorry. I'm very sorry, my lord. that
You
if I
have filed a writ in 2014.
my lord.
क्या कर रहे थे 50 साल?
अभी इन्होंने कब्जा तो हम मांगा हमसे, ये कब्जा इन्होंने सर 2012 में इन्होंने हमको नोटिस दिया, आप इसको वैकेट करिए लैंड. And my respectful submission is this, my lord, that as on today, my lord, sir, my lord, very pertinently, my lord, sir, my lord, said
What
that.
is the nature of your possession? Legal.
My lord, it is illegal.
If 9(3) notice has been issued, you would have been vacated. If you are vacated, then yours is a case of re-entry. We get into that angle. That is not the case here. We will not go into those issues.
My lords, my respectful submission is that my lords are presuming that the possession has been taken. I say, my lord, in very specific terms that the possession has never been taken over, compensation has never been paid. And both these aspects could have been answered by the state government. Assuming, my lord, they come out with a plea that the compensation, here is the document.
They have answered everything in their objection.
In their objection, my lord, they have not said anything about the
participation in the award, everything is good.
Well, they have come out with such a vague pleading. They have not said that we have paid it to the erstwhile owner.
They have matched the vagueness of your pleadings.
My respectful submission is, let them out at least.
So forget the faulty pleadings. Even in law, let us assume that these contentions have been taken. Even then, you have no ground to stand.
Let them come out with a single line that the award has been paid. The compensation has been paid. Either to me or to anyone else.
You first convince us, then we will think about it.
Because my respectful submission is that I have no other means to show that the award amount has not been paid, except to implead him as a party.
Did you seek for award documents?
Did
you ask them whether when award was passed, to whom you have disbursed? Did you ask them, doesn't the award say to whom it is disbursed?
The award is the, please see this.
Council, yes, contested it. It is not, you see, sometimes what happens? There has been a sale. Original owner does not participate in the proceeding. Award is passed. Thereafter, the collector will deposit it in the civil court. That satisfies the law. Many a time, money just remains there.
Yes.
Then if you go and prove it to the collector that you are the owner, then he may release it. But in this case, they have contested it on whatever ground, parasite. So obviously, the result of a contest is a receipt. They have taken it. That it's for you to get all that information. You should go to the collector and find out what happened to the award, how much you are given, what is the extent of land, who has participated, why did you allow him to participate? Because he is a notified owner. You are not the notified owner. Again, you are back in the same circle. Just because they have issued you a notice for eviction in the year 2000, whatever, that doesn't give you any right. So your nature of the possession again becomes problematic. You are not there as owner in possession as on date of acquisition. So 9(3) has been issued, thereafter they have taken possession, everything is over. Otherwise, how this department could hand over land to the other department?
We were one of the my lord, the submission is that as I, at the beginning, my lord, I submitted that our sale deeds were prior to the acquisition. We applied for diversion. The diversion, my lord, nobody raised any objection in the diversion process. The diversion was got, my lord, that order I have placed on record annexure P3, page 26. And in the diversion proceedings, my lord should kindly notice that the same Anuvibhagiya Adhikari, he passes an order on, my lord, this is on 1974. And this diversion is given, my lord, in the name of the society.
Even if you accept that submission, does that fructify into any legal right for you?
No, my lord, in fact, if diversion, if the acquisition, my lord, if the acquisition was, my lord, proper, then the diversion would not make any difference. It will not make any difference. What I am trying to submit before a lordship is that, I am not saying that. What I am trying to submit is that the authorities are aware of this fact. My humble submission is this, my lord, let the government, my lord, say that the compensation was paid to the.
If you counsel with these kind of pleading, this is the answer you will get. And they have stated everything in their reply. What more is required?
Before
you cannot go digging up the entire records. You are supposed to do it. And ask the government to do it. Have you surrendered the land or no?
Not so far.
Huh? Why?
They, in fact, they have to take possession. Some of the houses have been constructed there.
The society.
Society. So
when you constructed that house?
Some of the members, so the society allotted the land to the members.
They will not go for demolition.
If we do not get protection from a lordship.
No protection. No illegal protection.
Oh, may kindly see, we are invoking the equitable jurisdiction
No,
of lordships. It's a case.
It's for equity for people who are on the right side of the law.
We have not played any fraud. We have not committed any mistake. It's a matter of otherwise we have not committed any mistake. My lord, we have not committed any mistake. We have not played
When
any.
did you come to know of the acquisition?
Acquisition, my lord, the notices were received by us, my lord, from the Tehsil. Then, my lord,
when?
It was in 2012 months.
12? From 62 to 12, what you are doing?
The land, but they never, my lord, no efforts were made to take over the possession from us.
You have lost right title interest in the year 1962. How many houses you have built from 62?
There are about 10, 12 houses.
10 houses in 40 years.
12 houses. Because, my lord, the society has allotted the land to the members. It is for the members to use.
Not a what? Allotted.
If I can, as a last, my lord, submission to a lords, if I can place, my lords may kindly see that we purchased this land, my lord, for valuable consideration.
Until we are aware of all that, whether it's a fraud or not, we don't know. But 100% it is illegal. It is not authorized by law. You had no authority to alienate it.
Now, as on today, if my
And in 1967, when you came to know all these, Not even 67. You came to know it in 2012.
The project, my lord, which was supposed to be there, that project is not there. Now the land is required by them only for the purposes of settling down certain persons, my lord, who are to be shifted from some other area. The shelterless persons who are to be settled. This is the purpose which the government has, my lord, shown for our eviction. Now, my lord,
that's a public purpose, no?
Uprooting, my lord,
has to go. All have to be demolished.
To get settled
Yes.
some other. And it will be, my lord, by.
You have alienated land that doesn't belong to you. Actually, what are the consequences? May not be fraud or whatever, but definitely it's illegal.
Can they be asked, my lord, that whether they have paid?
We are not going to ask them. Why should we ask the government? You make out a case, we'll direct them. Court will never request anybody. You can request. You go pursue it.
He can make only a
Go
prayer
to
to the lordship.
Not by a hanging sword. So you want land or compensation?
Land, my lord.
Can move the government, let them do whatever.
They are rehabilitating others, my lord, by uprooting us.
Yes, what do you want to do? क्या करना?
Prayer, which we have.
Can't be granted. We'll clarify the entire position because there's a lot of jumbling up of law over here. Correct procedure in which it has been done. Yes, Gindiyal.
Others. So we are at the mercy of the lords.
No, we are not at the mercy. We are at nobody's mercy. You have taken a deliberate risk and done all this. It's all a planned, not some mistake that you are always entitled to move the government for protection. So it's a government land ultimately. They may give you part of it, they may save the structures or whatever. 26, I don't think we can direct them to do. Just to, you weren't saying you take the plan. Structured area, they can. Yes. Maharaj. What do you want to do?
We leave it. We leave it to my lord's government.
Then we'll dictate. That's the best thing we do.
My instructions are that.
Because you will lose your chance of even going to the government then. Yeah. Take on.
Actually, my lord, we have no hope from the government because they have already, some of the constructions they have already.
That's a different matter. Your hope in a petition should come from law. Here, how it is done, I mean, we don't even require so many pages to dismiss it. I've been asking you because once you pass an order, then even the, our hands will be tied. Then you cannot even move the government. So demolish हो गया वो तो
Or can I get some time to seek instruction?
the matter of some time, when senior council seeks time, they request call out of 4 weeks.
Great. I'm obliged.
The order at claim number 8 has not been complied with, Lord.
GA takes notice for respondent out of 4 weeks. नहीं लंबाई करो पूरा यहाँ पे
This matter pertains to school education gas feature.
What is this dealing?
Gas feature school education.
What is this IA?
Sir, IA for delinking this matter because it is directed by the registry to consolidated hearing with the bunch matter of guest faculty. They belongs from the colleges and the university. This matter is different to this nature. This belongs to school future of middle school, your lordship. So this application for delinking and send back this matter to Indore bench.
No, all guest faculty were hearing here only.
Lordship, these guest faculty belongs from colleges, school and higher education. This matter belongs from school education, Lord.
That we are hearing all the cases here.
So all more than 600 cases belong from school, higher education, colleges.
Right, but we are hearing all those cases. We'll hear you also. Please tell us what you are.
Your lordship, the annexer given
with
the petition is the circular of the government to engage the guest faculty. And this petitioner is the English teacher and working since a long, and his scorecard is not appreciated according to the circular clause 2.1, which is on page number 28 of the petition, running page number 28. Shall I read?
Yes.
विद्यालय जिसमें रिक्त वाले पद एवं विषय पर पैनल पूर्व से उपलब्ध है, उन विद्यालयों में अतिथि शिक्षकों के आमंत्रण में माननीय उच्च न्यायालय द्वारा दिनांक 10/11/2008 को दिए गए निर्णय के अनुसार कंडिका 27(2) का पालन किया जाए. The vacancies, if any, the guest teacher engaged in pursuance of the circular dated 7/7/2018 shall be filed upon the basis of the merit list school-wise already prepared. So, Lordship, this merit list is not prepared. My scorecard is not considered appropriate. I am working since long, and I have not been continued as a guest teacher in English.
Yeah.
So, several representations have been filed by me.
Yeah.
And all representations are pending before the authorities, and no representation have been considered.
Yeah.
And my document, my academic qualification, and all representations are on recorded. Here in the
Then you were above respondent number 7 in the merit list.
Yes, Lordship.
There is the before. अब कितने मार्क्स थे आप?
Merit list is not.
The petition is silent about that. Petition में mention नहीं किया. How to appreciate
Give
your
me a liberty to keep it on the part.
dismiss as liberty to pursue such remedies as available.
Well, it's my appeal pending before the state commission. The state consumer commission was dismissed for want of prosecution. For the reason, my lords, that the said case was not listed on the date fixed for arguments or for final arguments. The impugn order is at page number 2, my lords, page P2, page 35.
What is wrong with it?
My lords, the case was not fixed. The case, my lords. This says that the matter came up for hearing on 11/11/2022.
Yeah.
However, my lords, the order sheet at page number 41, order sheet dated 1/9/2022, page number 41, my lords. Bottom says list for final hearing on 7/11/2022. Now, my lords, my case is missing from the cause list of 7/11/2022. I have annexed the entire cause list of that day. And it finds mention in the cause list of 11/11. Hence, my lords, I had no opportunity. The council was never notified to represent petition, and hence it was dismissed. And hence I am before the lordship that the said case was not taken up on 7/11, on which it was fixed. Instead, it was taken up on 11/11, and there is no rollover of cases. Every day it is a fresh list, even for final hearing cases. So, my lords, it was not as if the case was listed on 7/11 and it was not reached, or it was.
Where is the final hearing list?
Of 11/11 or 7/11?
7/11.
That starts at page number 49, my lords.
That is further order. Where is final hearing?
Lordship.
Where is the list for final hearing?
Yes, at page number 60. This is the entire process.
16. Notice.
Wait for it.
So, Shobha Gadke is our guest faculty, sir. She was appointed 2011 and she posted there till today. Also, sir, there is a notification, circular has been.
What are your facts, Mr.? What is your case?
I want to, sir, kindly issue notices to that.
Not so simple. Everybody wants notices to be issued. You have to earn it. Tell your facts.
So my fact
Kindly
is-
issue notice, kindly grant interim order, बाद में देखेंगे. ऐसा नहीं होता सर. What are your facts? Have you read your file?
Yes, yes.
Yeah, kindly tell us.
So my fact is to, sir, please, sir, any sort of, sir, that is a circular which was given by the government of MP.
Who are you?
Sir, sir, I'm a Shobha Gadke, the faculty, guest faculty.
When did you become guest faculty?
Sir, in 11/4/2021.
How long you have worked?
Sir, it is almost about 2 years, sir.
Then what happened?
Sir, the college, the principal who told them to remove from the post. So I got any sort of order. Continue. So ये आपका साइट एकदम भी है।
अभी काम कर रहे हैं?
Yes, sir.
11/3/2023 तक आपका टेन्योर है।
Yes, sir.
तो अभी आपको कहाँ हटाया गया है?
Sir, but sir, after 11.
ये तो प्रीमेच्योर पिटीशन है, आपसे हटाया नहीं गया आपको।
Sir, there is certain orders of honorable court.
And with respect to those teachers who have been removed, you are still working. Your tenure ends on 11th of March 23.
Yes.
अभी कोई कॉज ऑफ एक्शन नहीं है आधा।
Give any liberty, sir, that she'll be not be removed until and unless the next permanent faculty.
You can file it when cause of action is there.
Kindly give liberty, sir.
Dismissed. Yes, who appear? Who appear? Council absent, call after 8 weeks.
Lordship, I'm praying to withdraw this petition in light of order dated.
Order.
Lordship, there's a arbitration case number 17 of 2023 that is pending before this honorable court. I'm praying for liberty to be granted to pursue that.
Whatever liberty you have, you do it. Next.
21. For 2 days time to file a document which is mentioned in the impugn order.
Yes, what is this matter?
Sir, मैं मिलके आया हूँ हार्ड कॉपी में पेश नहीं कर पाया तो 2 दिन का समय।
What is your case, Mr.?
Yes, my lord. My lord, the permission that was granted to me regarding environmental clearance, my lord, has been revoked, my lord. My lord, we just see page 30 in the last paragraph, my lord. And
Page?
without any inquiry, my lord, it has been done, my lord.
So,
Sir, उन्होंने कहा कि आपने
what are you?
release holder.
What are you doing there?
I am conducting mining operation for that excavating flagstone, Lord. Minor. सर बिना इंक्वायरी के मेरी परमिशन विड्रॉ कर ली.
कोई जरूरत नहीं है. CA takes notice for 1, 2,
1, 2, 3.
3.
Include order is by 4.
Give notice to remaining respondents post after service of.
May be permitted to state the operation.
Let them appear. Without them, we cannot pass an order.
Okay.
But in this case, my lord, I have filed this petition for the limited relief. Lord, in fact, what has happened, my lord, of contract is.
Where is admitted amount?
My
Page.
yes, page 65, ma'am.
This is your letter.
No, my lord, it is there. उपरोक्त विषय अंतर्गत कि इस कार्यालय द्वारा संचालक तकनीकी शिक्षा एवं कौशल विकास विभाग से कुल.
This letter is written by whom?
My lord, written by PWD Department Executive Engineer.
60?
65, my lord.
4.
4.
Huh.
My lord, letter written to us.
Yes, government.
My lord, you kindly have page 66 and 67. Lord, the Honorable Court has already disposed of the petition saying that substantial grievance has been meted out, and in case anything subsists, then you are required to invoke arbitration.
But he's saying some admitted amount.
Yes,
So this is, this letter is prior to the order of this Honorable Court.
Have you paid that or not? At least that.
My lord, even 64.
Verified.
That I'll seek.
ये takes copies for 1, 2, 3. कितने लोगों से कितना पैसा लेना है?
My lord, in fact, what has happened earlier, it was the contract was awarded by Capital Project.
Who has admitted the amount?
My lord, government, because now it
Which
is
respondent?
Respondent number 8, man.
Huh?
8.
Then why others are a party?
Because they have awarded me the contract, therefore.
How are they concerned with it?
But I agree, my lord, what my lord says is correct. But because I thought it may not be become misjoinder of party, therefore the person who has awarded me the contract.
You may think whatever you want. You want admitted amounts to be released in terms of P8.
Yes.
Whose author of P8 alone is concerned?
My lord, it is respondent number 5.
1 and 5, 1, 2 and 5.
Yes. I will delete it.
CA takes notice of 1, 2 and 5. At request of petitioner counsel, remaining response are deleted. Payment post title file amended petition by next week. CA takes notice for 1, 2 and
5.
For out of 4 weeks. Yeah.
Not in this matter, petition was filed by section 4 to 6 for the PI. The head of PI and it was filed out, seeking a direction against the petitioner. And in that, there was no specific order on Melik's part. It was the direction that his representation be considered by the collector.
Yeah.
Now, on the basis of that, Lord, collector registered a revenue case, Lord, and he has started the proceedings, and only on the basis of the documents which were placed by respondent 426, he is proceeding against us. We have asked for cross-examination of the respondent 426, not on the basis of documents which they have filed, which the collector is taking cognizance of. So that has been refused, not that application was dismissed, not, and we have also made a prayer that he will be given because there is a specific direction by the court.
What is he proceeding now?
Lord, there was an allegation that the construction.
What are these for proceeding, Mr. 2123? What is this order?
Lord, this is the order whereby my application for summoning the respondent 426 for cross-examination has been.
Cross-examination for what?
Because they have moved an application before the collector pursuant to the direction by this honorable court. Lord.
Whom you want to cross-examine?
Lord.
Where is your application?
Order.
The order says you want to cross-examine somebody.
3 persons, Lord.
Where do we get it? You can't tell us like that orally. Who are those 3?
That application I'll have to. What I have not.
Then we'll see that now. And how it is relevant, how it is not relevant.
Because the collector is taking.
And why this 4, 5, 6 are a party?
They are the person who preferred PIL before your lordship.
How are they concerned with this?
They are not. This is what I grievance is that they are not concerned. They were not concerned with my.
Then why you made the party?
But because they preferred a writ petition before.
Bol diya na ek baar. Does it have any nexus? What is your prayer? To seek permission for
cross-examination,
summoning or whatever it is. How? Why they are required?
Because they preferred. They have filed certain documents before the collector. The proceedings have been initiated.
10 times you have to go to.
Lord, I'll bring that application on record to clarify Lord my argument.
Understand what you say yes, and again you tell the same answer again. This is between you and this court. Correct? Whether to allow you for cross or not depends on the court. How these people are necessary? Again you are saying no, they fault PI. This is between you and.
Because I have not got those documents, I have not.
No, forget the document. It is between you and this court, whichever court this is.
Correct.
Then why private parties are required?
I'll have to seek instructions, but I don't have documents, therefore I am unable to address it. Why they are relevant, Lord? Because there was an order.
Nothing.
I'll place documents on record. So that.
Even for the writ petition to come to the stage of being considered for admission, we have to adjourn it 10 times.
That's it.
You don't know what document to file. You don't know what law is there. You don't know what fact is there. You have to adjourn. No wonder we can't make any progress. Matter is arguing for admission counsel. And you don't have documents.
I apologize. I'll file this.
No, not a question of apology.
Even I.
How much of court time is wasted in this? You must think of all this before you file it. Again we'll give time, again you will bring. You will bring 3, you don't bring 2. Again we'll ask questions, again you take time. Again you will bring it. 4 weeks at petitioners.
Flight training school. The petitioner is a flight training school.
Yes.
Because I have a 15-year lease on the Rewa airport in Madhya Pradesh starting from 2019. By the own email, my lord, which is at page number 114, out of the blue I am informed that the airport is being handed over to the airports authority for upgradation and all flight training must stop. At the moment, my lord, we have 64 flight training cadet students who are waiting in line.
Where is their contract permitting you to do all this flight?
Yes, my lord. That is Annexure P2 starting at page 22, my lord.
Does that not postulate a situation where it can be withdrawn?
No,
There is, however, a situation known as a step-in. Allow me to take a that will, my lords, we come at page 72 of the contract, 17.1. If I may read, my lord, notwithstanding anything provided in this agreement at any time during the term of agreement, authority, which would be the Madhya Pradesh Civil Aviation Authority, may have the right to undertake any upgradation, development, or construction work at the airstrip at its own cost and expense, without any relatable payment to the developer, me being the developer. During the period in which authority assumes control of the airstrip for such work, the duties and obligations of the developer shall be sustained.
Where are you reading?
Well, that's page 72 of the paper book, clause 17.1 of the contract. My Lord, the Chief Justice, page 72, right at the top.
This is all right. You come to clause 12.7.
Yes, Thomas. Yes, Thomas. Well, with regards to disputes, well, my contention is this. At this juncture, I'm not raising a dispute primarily because I do not wish to take an adversarial stance. My argument is AAI has now come in without informing me. That's my submission. Upgradation of this is not something that will happen mechanically, my lords. The task of upgradation will include land acquisition, making the terminal building. AAI can permit me to conduct my flight operations for a minimum of 4 to 5 months. On instructions, my lords, the state of Madhya Pradesh is now trying to offer me alternate arrangement. It should have been done at least a year in advance, but they are trying to do so now. But the nature of the training is such, my lord, that I can't move from point A and go to another airport and set up operations. To get DGCA approval, I need a minimum of 6 months. So my request before the court was this, my lord, if AI would file an affidavit in a short period of time saying, is it possible for them to work on another aspect while the students continue with their training? I must also point out, my lord, that by a stroke of extraordinary luck, these students are studying at a time when the largest airline recruitment is about to happen. That's the Air India 900 pilots. What was extraordinarily lucky for them will now turn to ash if they can't complete their program. There are only 1,000 airline pilot licenses granted by DGCA every year, out of which 500 are from outside India, 500 are from India. This school, the school itself is something which is not something that can be overlooked. And the way and manner in which AI and the Civil Aviation Department have worked, fortunately, my lord, leaves a lot to be desired. They work without any sort of prescience. They have not informed me at all. Even the order, my lords, referred to in their email, the order of the collector has never been served. Up until now, there is no order officially which has been served on me, informing me about this upcoming upgradation, informing me to apply for maybe another airline or another airport, or even informing me that please stop working with the collector's order. I receive an email out of the blue and thereafter everything has been suspended. I'm limiting my contention for now, my lord, only to this. AI is an expert body, no doubt. I do not wish to stand in the way of RERA being upgraded at all. I had a similar airport in Ayodhya, my lord, in 2009. I was informed and I vacated in 2022 despite the lease rights because I understand that airports have to be upgraded. But allow my flights to continue. You can work on other aspects of this airport and you can develop it side by side. Just another submission, my lord, I have around 20 aircrafts there right now. Even if I have to move them, let's see, if by some miracle I can set up another school in a week's time, they have to fly out of that airway. If you aircrafts on the ground can't fly out.
Do you have any single legal ground?
My ground would be
none of this what you said impresses us. We are not concerned with your aircraft. We are not concerned with anything.
I'm only asking that
there is a contract between you and these people. They have violated it. There is a clause to do it. Go ahead.
The students also have a right.
Just let them come, then we'll see.
I would only request
the
court to be sympathetic.
We are not concerned with all the Ayodhya and all that. What happened? What are we concerned with that? Some Air India, somebody buying 20,000 aircraft, why are we concerned with that? You are going to get a good job, how are we concerned with that? What's your legal ground? Zero.
Well, the legal ground here is that the state has to, the administrative orders of the state have to be reasonable.
Okay, this you are under contract, you are not an administrative law.
Manoj, the
Isn't
administrative
it?
order
You
of,
derive a right under contract.
yes, Manoj, I am a leaseholder.
That's all. So
Manoj,
contract
there
is
are
violated.
judgments of the
If
Supreme
contract is
Court.
violated, what's the
Manoj,
remedy, counsel?
permit me to show one judgment, Manoj, on this issue entirely.
Hello.
Manoj, a copy has been provided, para 27. Yes. Issue hearing was also whether an alternate remedy would bar powers of the High Court under 226 to interfere.
That's a settled law, we don't want that.
Yes.
There's no compulsion.
No, of course not. It is only discretion. There is only discretion, Manoj, and the
You better fly your disputes to the government. Don't be grounded over here.
the damage which will be done to the students will be incalculable.
There's no point crying about it. You are under contract. There's violation, you deal with them.
The way in which the government is mandated to work in a way as envisaged under the Constitution. The directive principles of state policy exist for this purpose. To have an unreasonable ground, tomorrow the government comes across and locks a school up in the middle of the night, to then say that no, there's a contract, would, in my opinion, Manoj, not be the proper way. The government must work in a manner.
Your opinion doesn't matter to
the normal contract holder, Manoj. The government is not a builder. The government.
Your opinion doesn't matter to
Not
the
at all,
government.
Manoj. I'm only making a submission. All due respect,
We
Manoj.
don't see any ground.
But I'll then request for an order.
What is P3?
Yes. P3, Manoj, is the email that I received. On the bottom email, Manoj, is the email, which is the improved email that I received out of the blue on 12th of February 2023 at 7:47 p.m., wherein they come in and tell me that the airport has been given over to AI, stop all flights. I respond to that, Manoj, on 12th at 8:54 p.m., asking them not to do this. Before, my lords, are the pictures wherein the entire runway has been dug up.
The digging is for which?
Reva Airport. Reva Airport.
Is there an airport in Reva?
Well, the airfield is there. It's only the flight school was there till now. Now they want to upgrade it. Submitting, my lords, again, that the upgradation can happen side by side with limited notice on this ground only, my lords.
The instruction?
Won't have any instruction.
Appeals for airport authority.
Anup Nair.
Anup Nair.
Get him, we'll take it to.
Yes.
Lord, I prepared a really short list of dates, chronologically, my lord.
Have you seen
Respect-
it, Krishna?
My lord, he has supplied me just now.
I have just prepared it, my lord. for
Ready
the-
or take it tomorrow?
My lord, we take it tomorrow, my lord. I'll also verify it.
My lord, a return is also required to be filed, my lord.
My lord, in detention cases,
Ji.
my lords gave
I will,
to
as my lord. I'll try to file the return tomorrow. Otherwise,
Day
dates.
after, take it day after.
day after, my lord, and by tomorrow's evening.
Worship, two sessions trials were tried together, one by one, and by way of a common judgment, the two accused persons have been convicted. I have just checked up the file in ST number 287 of 12 in the connected case is not available, sir. Trial court की आई नहीं है.
What you want now, counsel?
सर उसमें फाइल बुला है दोनों एक साथ सुन लिया उसमें ST नंबर 287 ऑफ 12 की फाइल कॉल ये 267 ऑफ 12 की आई है.
So and so, call for records in 5.1 correct. What is the case number? I see.
ST नंबर है सर उसका 287 ऑफ 12.
Post after solution.
है उसमें पन्ना लगाया ऊपर एक मिनट दिखाई पन्ना दिखा था मेरे को सिर्फ लिस्ट अगर है तो अभी करूंगा. Yes, sir. ठीक है उसमें एसटी नंबर हाथ लिख दिया है डिपोजिशन शीट में नंबर लिखता है.
Take it tomorrow.
लॉट
Take it tomorrow. Can go through.
टमाटर वेज
Well, this is first application for suspension of sentence.
Yeah.
A conviction under section 363, 366, 376(3), that is rape below 16 years girl, and passport. My lord, kindly my lord see the deposition of the girl. According to prosecution story, this appellant, who is only 20 years, took the girl by bicycle in the field, wherein slapped her and committed bed work. That is, this is the process. She has not stated about the committed sex or sexual intercourse. She has stated the bed work was committed. So, kindly see the statement of PW2.
Did the offense take place?
My lord?
How did the offense take place?
My lord, in the forest area. May I read the prosecution case? My lord, the para 3 judgment case, kindly my lord. May I read?
Yes.
अभियोजन मामला संक्षेप में इस प्रकार है कि दिनांक 13/10/19 को करीब 12 बजे फरियाद या सूचनाकर्ता उसकी भतीजी के साथ खेत में सोयाबीन व घास काट रही थी. उसकी भतीजी पीड़िता पानी पीने बोलकर कुछ गई. कुछ देर बाद उसके ससुर आए.
Para 3. He has narrated the incident. These all matters for trial. We can't distinguish that now. At bail stage. Yes. Yes. Yeah. Yes. 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 Yes, go on. Okay, reply. Have you filed reply or no?
Your Lordship, the reply has been filed on February 10th, 23.
What does the doctor say?
Well, the doctor is Sunita, Dr. Sunita Barua. She has stated पीड़िता के चेहरे पर दाईं तरफ खून की आंख की सूजी थी, पीड़िता की दाईं आंख में नीले निशान, आंतरिक परीक्षण, हाइमन उपस्थित नहीं था, हाइमन फटा हुआ नहीं था, आंतरिक अंगों में कोई चोट के निशान नहीं, बलात्कार के संबंध में कोई स्पष्ट मत नहीं दे सकते.
Yes, sir. My lord, that aspect has been dealt with in para number 48, my lord, regarding the doctor's report. My lord. Have you permitted to read aloud? बचाव पक्ष द्वारा तर्क किया गया कि प्रकरण में डीएनए रिपोर्ट प्रमाणित नहीं हुई है, अतः आरोपी के विरुद्ध निष्कर्ष नहीं निकाला जा सकता. अवलोकन से प्रकट होता है कि प्रदर्श P15 की डीएनए रिपोर्ट में लेख है कि पीड़िता के स्रोत तथा ए तथा बी से एम्प्लीफेबल पुरुष वाई क्रोमोसोम एसटीआर डीएनए प्रोफाइल प्राप्त न होने के कारण इनका मिलान आरोप के रक्त नमूने से प्राप्त डीएनए प्रोफाइल से नहीं किया जा सकता. किंतु प्रदर्श P14 के एफएसएल रिपोर्ट अनुसार पीड़िता के स्वयं प्रदर्श ए तथा स्लाइड P1 पर वीर एवं मानव शुक्राणु पाए गए. अब यदि यह भी लिया जाए कि प्रदर्श P15 के डीएनए रिपोर्ट नकारात्मक प्रकृति की है, तब भी यह विचारणीय है कि क्या पीड़िता के एकमात्र साक्ष्य इस संबंध में निष्कर्ष निकाल जाने हेतु पर्याप्त है। After all those judgments have been relied upon to reach to a conclusion, para 51 my lord. Para 51 my lord. यद्यपि प्रकरण में डीएनए रिपोर्ट ऋणात्मक है जिसके संबंध में ऊपर विवेचना की गई है और तब ऐसी स्थिति में डीएनए रिपोर्ट ऋणात्मक आने से संपूर्ण मामले को खारिज नहीं किया जा सकता। दूसरी ओर प्रकरण में करीब 15 वर्षीय पीड़िता ने बाल संघ होने के संबंध में स्पष्ट साक्ष्य दिया है जो प्रतिपक्ष में अखंडित रहा है। घटना को उसकी चाची अभियोगी साक्ष्य क्रमांक 3 ने स्पष्ट रूप से पुष्ट किया है। अतः डीएनए रिपोर्ट की प्रदर्शनी 15 के ऋणात्मक होने के आधार पर अभियोजन के प्रतिकूल निष्कर्ष नहीं निकाला जा सकता। मतलब then the doctors
डॉक्टर
मतलब दिस इज सुनीता शर्मा अभियोजन साक्ष्य क्रमांक 6 पैरा 52 मतलब वन मोर पैराग्राफ में रीड मतलब 52 मतलब बचाव पक्ष के द्वारा यह भी तर्क किया है कि पीड़िता का मेडिकल परीक्षण करने वाली चिकित्सक डॉक्टर सुनीता बरुआ के द्वारा बाल संघ के विषय में कोई निश्चित अभिमत नहीं दिया है। अतः बचाव पक्ष का तर्क है कि पीड़िता के साथ बालक संघ किया जाना प्रमाणित नहीं माना जा सकता। यहाँ यह उल्लेखनीय है कि डॉक्टर सुनीता बरुआ ने अपने अभिमत में बताया कि बाल संघ के संबंध में एफएसएल की रिपोर्ट के पश्चात अभिमत दिया जाना संभव है। इस संबंध में न्याय दृष्टांत स्वयं में अभी निर्धारित किया गया है कि चिकित्सक द्वारा ऐसी अभिमत नहीं दिया जा सकता कि बालक संघ का कोई साक्ष्य अथवा चिन्ह नहीं था। इस न्याय दृष्टांत में मोदी के मेडिकल जूरिस्प्रूडेंस स्वयं के पृष्ठ क्रमांक स्वयं में संदर्भ है उद्घोषित किया गया है कि रेप इज अ क्राइम एंड नॉट अ मेडिकल कंडीशन। Rape is a legal term and not a diagnosis to be made by the medical officer treating the victim. The only statement that can be made by the medical officer is there is evidence of recent sexual activity. Whether the rape has occurred or not is a legal conclusion, not a medical one. डॉक्टर सुनीता बरुआ ने अपने मुख्य परीक्षण में पीड़िता के चेहरे पर दाई तरफ सूजन और आंख पर सूजन तथा पीड़ित के दाई आंख पर नीले रंग के निशान होने का कथन किया है, जिसके संबंध में पीड़िता की चाची अभियोजन साक्ष्य क्रमांक 3 ने अपने मुख्य परीक्षण में कथन किया है कि पीड़िता ने जंगल से लौटते समय पूछने पर बताया था कि आरोपी ने उसके साथ मारपीट की थी। स्वयं पीड़िता ने भी अपने मुख्य परीक्षण में आरोपी द्वारा उसके साथ मारपीट किए जाने का समर्थन किया है, जिसकी पुष्टि डॉक्टर सुनीता बरुआ अभियोजन साक्ष्य क्रमांक 6 की साक्ष्य से होता है। Accordingly, in para 55, the conclusion has been drawn, whereby it has been stated that the only evidence with regards is to the exhibit number P14, which is the underwear of the prosecutrix, where it has been the that has been found. With regards to that, the learned court below has dealt with this judgment, where it has been stated that it is not
signs of the offense being committed.
That conclusive
376 is other offenses are circumstantial. 376 can't be circumstantial.
That medical evidence has not come.
old is the victim?
20 years. 20 years.
Victim.
Victim is malad the below 16 years. 15 years and malad 7 months. Minor, this is the admitted position, malad he is minor. He is minor. Below 18 years, he is. For malad, the rape was not committed. This is my submission. For other sections, he has served.
What is against you?
Against me, but malad the DNA is not. DNA is in my favor. DNA is negative. आपने भी पढ़ा 2 बार 3 कह रहा the DNA.
DNA report has been withheld awaiting FSL report.
But malad, my submission is ocular evidence may kindly be considered. He has not stated about the rape.
If FSL report is against you, where
My lord, my submission is, if my lord, in the 375, my lord, the ingredients of rape is defined, and my lord, she has not stated about the 375. So my sense, she has stated Gandakam. The Gandakam is the many. My lord, put up the clause is Gandakam. Outage the modesty is the Gandakam. The various, so my lord, my submission is. Yes, he has served 3 years, and the appeal will take more than 15-20 years. My submission is.
Para 3 of the cross, she has narrated in detail.
She is stated Gandakam. And again, malad.
क्या बोल सकते?
नहीं. She should be malad that explain the all ingredients which are required for the purpose of this rape. Gandakam, my lord, if the person put up the clause of the girl, it's a Budakam. Outrage the majesty, it's a Burakam. It's a Gandakam. And twice he has not stated, my lord, in the exam in chief. एक बार और समय दिया, दोनों बार he has not. In the cross examination, after declaring both sides, put up a legal question, then she has stated Gandakam.
Gandakam has been dealt with in para 37, my lord. बचाव पक्ष के द्वारा तर्क किया गया है कि पीड़िता ने अपने मुख्य परीक्षण में गलत काम एवं गंदा काम करना बताया है और उसकी चाची अभियोजन साक्ष्य क्रमांक 3 ने भी गंदा काम करना बताया है, जिससे बालक संग किया जाना नहीं माना जा सकता। जहां तक पीड़िता के द्वारा गलत काम के बारे में बताने जाने का प्रश्न है, इस संबंध में न्याय दृष्टांत अनु उर्फ अनूप कुमार विरुद्ध स्टेट ऑफ एमपी ILR 2008 MP 2435 में अभी निर्धारित किया गया है कि शब्द मेरे साथ उसने गलत काम किया, इन शब्दों का अन्य परिस्थितियों के साथ देखें तो स्पष्ट है कि अभियुक्त्री ये कहना चाहती थी कि उसके साथ बालक संग किया गया है। अतः अभियुक्त्री के द्वारा कहे गए शब्दों का समग्र परिस्थिति में देखना चाहिए।
Shower, disputes a whole. It was alleged by her that her niece, victim, Lucia, the minor girl, that she had gone for taking water on 13/10/2019 at about 12 noon. She did not return. When they went in search of her, they found her in the forest area. On questioning her, she told them that the appellant took her on a motorcycle to the forest area. He assaulted her and committed bad work on her. Thereafter, the complaint was registered. Investigation was taken up. On trial, the appellant, the sole accused, was convicted and sentenced as follows. It's the instant application seeking for suspension of sentence. Counsel when contended there is no material to convict the accused. The innocence of the allegations made against him. The DNA report does not support the case of the prosecution. That even the statement of the victim does not support the prosecution. And she pleads that bail be granted. The same is opposed to by the respondent. The Land Council did not find any merit in this petition. Admittedly, the victim is aged about
15 years and 7 months at the time
of the date of incident. She has stated in the cross-examination at para 3 the detailed manner in which the appellant has committed the offence. He has stated as to how and in what manner the offence has been created. He, being the victim, has clearly narrated the offence against the appellant. The same has been rightly considered by the trial court. So far as the FSM report is concerned, the same is supported the case of the prosecution. It is stated therein that
exhibit, para 48, exhibit P14.
even though the appellant was found on the article sent for examination. So the prima facie view that the trial court was justified in appreciating the evidence when convicting the accused. However, they are all matters for trial. So far as grant of bail, suspension of sentence is concerned, we do not find any good ground for the Mr. Nair, you take notice for this.
Yes, my lord, I'll take trial.
You should stop doing work there because for the time being at least. But digging up the entire runway out.
My lord, the Riva airport is, they are upgrading the entire airport and we said
But
yes.
there's a manner to which you dig it up, this man cannot even remove his aircraft.
Seek instruction, my lord, because I do not have, what is the status at present?
A takes notice for 192, Nair for R3. Who is R4?
R4, my lord, is the airport officer, the officer of the Airports Authority of India delegated at that airport.
Why have you made him in the personal?
My lord, he is not important, my lord. I will delete him.
R4 is deleted from the proceeding. Amend the cost title, file amended petition by next day. Here on record which indicates that the respondent 3 is digging up the
runway
at the
Reva airfield. Reva
airport. The petitioner counsel submits that with respect to the contention, how many aircraft here?
Your Lordships, we have a total of 13 aircrafts, my lord.
13 aircrafts. They are stationed at Reva?
Yes, sir.
Stationed at Reva airport, and in case the digging work continues, all the aircrafts would get stuck. That there are 69 enrolled students who are pursuing the course of commercial pilot training. Therefore, all this would come to a standstill. The voucher came to note. Hence, we deem it necessary to direct the respondent number 3 not to continue further digging or doing any such activity on the runway until further orders. All after 4 weeks. Existing land and Chora Hata airspace at level. Correction.
Only request, my lord, if it could be kept on a Monday or a Friday, whenever. That's the only thing.
I think we have done enough favor to you.
Oblige.
Or they may supply me.
Of course, I'll just.
Your Lordship, by filing this petition, Your Lordship, the petitioner is challenging the impugned order passed by respondent number 4, Your Lordship, which is annexed at P6, Your Lordship.
This is not revisable.
My Lord, by filing this petition, Your Lordship, the petitioner is challenging the impugned order passed by the.
इसका रिवीजन है कि
My lord, after that an impugn order, appeal has been preferred, Your Lordship, before the Commissioner, Your Lordship, at Annexure P9. Your Lordship, the petitioner has deposited the amount, Your Lordship, and
How much is the amount involved?
my lord, the amount of rupees 2 lakh, Your Lordship, it has been deposited by the petitioner, Your Lordship. And Your Lordship, in the absence of any provision, Your Lordship, the respondent number 4 has ordered for the confiscation of the vehicle, Your Lordship. There is no, in the rules of 2019, Your Lordship, there is no provision.
On ground.
My lord, that the vehicle was transporting the illegal side, Your
You
Lordship.
have been fined for that.
My lord, yes, Your Lordship.
Lord, initially fine was imposed, my lord, but he did not deposit the fine. Therefore, the collector passed an order of confiscation by exercising powers under 96. Now, in the peculiar case, my lord, before the commissioner, he has deposited the fine.
When was he supposed to deposit?
Lord, the commissioner says, my lord, the collector order was for 15 days. That was 5/7/21.
When did he deposit?
My lord, he has deposited in installments, my lord. The last has been deposited, my lord, on 2nd of February 23.
How many days later?
Approximately two years.
2 years?
No, Your Lordship.
21 में collector का order.
Your Lordship, after the show cause notice, Your Lordship, the petitioner has
1.5 years.
submitted clarification, Your Lordship. 1.5 years.
You want the vehicle or you want to argue?
My lord, vehicle.
Put in some more money. Close it.
My lord.
You pay some more amount.
Your Lordship. My lord, as per the provisional.
Favorable order also you don't take advantage. What is it?
My lord, as per the provisional, Lordship.
Argue.
No, my lord, my lord.
देखेंगे कानून क्या है ये क्या है.
My lord, as per the provision of 2019, Your Lordship.
Judgment will.
उसके बाद अमेंड कर दिया है. रूल्स अमेंड कर दिए.
Okay, we'll consider the
My lord,
issue rule and file objections by next week.
My lord, if my lord may release the vehicle, my lord.
That's what we told you.
My lord.
10 minutes back. You
My lord,
want
my
to
lord.
give judgment.
My lord, my lord.
कानून चाहिए गाड़ी चाहिए.
Gadi, my lord. My lord.
Deposit some more amount.
My lord.
How much?
Any reasonable, my lord.
How reasonable you will take?
My lord, any reasonable, my lord, because at that point of time, my lord, he
He
was
was
not.
asking you. You are saying whatever you say will give.
My lord.
Once we say something, then you will again bargain. How much you will pay?
My lord, for that, my lord, I need to seek instruction, my lord. What is his capacity, my lord? How much he can pay? My lord.
Lordship, this is the identical issue as has been considered by this honorable court in WP number 6159/22 जो annexure P2 है.
6159.
Yes.
Government.
Page number 50 to 50, please. 50 to 50.
None of these cases we are coming. Only because you are filing it, we are granting orders. Otherwise, each one of the cases has to be.
No pleadings to that effect that we are trying to change them or replace them.
By case appeal against the acquittal, Lordship. Execute the judgment finding the dated 12/12/2022, Lordship.
You have been convicted.
Lordship.
Huh?
Acquitted. No, acquittal, Lordship.
Acquitted. You are the complainant.
Lordship, I am complainant.
It takes notice for art fight. If you notice the many respondents. Admit. Call for it. What's the delay, government?
application time.
The office report indicates that the appeal is within time. Hence, I number so and so dismissed as being misconceived. Appellant counsel is absent. CA takes notice for respondent 1 to notice to R2. Admit. Call for records.
Your Lordship, last Monday, this matter was adjourned as per request of Mr. Rupra that he needs to file additional affidavit and in between he will catch 150 auto rickshaws per day.
Catch?
Yes, Your Lordship.
What Rupra? You didn't catch any auto.
Your Lordship, on instructions of RTO Jabalpur.
He's saying Rupra said he'll catch autos.
He is mouthpiece of Mr. RTO, Your Lordship. Copy not served, please.
Want to go through or?
No, Your Lordship.
Arey, पढ़ तो लीजिए.
I will read it.
Unless you had earlier information about it.
No, I don't have it.
You don't have. The action taken report is filed by the respondent state. The same is taken on record. Call after 2 weeks to consider. Petitioner's request. Yes, Gilder.
Well, in this case, they were to file reply notes, the notices were issued.
Yeah, yes.
It's a promotion matter,
Yes, sir.
The reply is awaited, Your Lordship. We had filed a reply before.
What are you challenging?
As a promotion, he was denied promotion to the post of head constable, Bigler, my lords.
What's the urgency now?
They were to file reply.
Any urgency for you now?
The juniors have been promoted, except that
What does the learned single judge hold?
The aspect that he was not nominated for the promotion cadre and the juniors were nominated. That aspect. They may be granted some time.
Urgency counsel, if you succeed, you will get all the relief. For learned counsel, admit. Reply if any by next date. The appellant to take out fresh notice on
Respondent number
unserved response. वो 4 5 है वो.
One. Great.
In this case, the petitioner appellant filed yesterday appeal against the order passed by the petitioner's judge family court, herald by which the tribal court has rejected the application filed by the present appellant under section 13(1) and Kha.
I am for the respondent, Mano. I pray for 2 weeks time for filing reply of interim applications.
ये क्या है modification?
In fact, earlier this honorable court directed to file this certain orders, but the applicant was in the jail where that same has not been filed. Therefore, I move an application for recalling that particular orders, my lord.
All after 4 weeks at response. Yes, comment. Where is PK Sharma? Where is R2?
Kindly keep in pass over minutes to kindly pass over minutes to Ganguly is having what I just called. He is there for responding.
Not Ganguly, the Sharma is required. PK
Sharma.
Sharma. We should envy a bailable warrant against him. Yes.
PK Mishra.
What is the possible?
Yes.
Application under the National Highway 38, 1956. Application before the Commissioner.
Is a reply? My lord, the reply is awaited. My lord, the NHI is also a party. My lord, sir, posed the question as to from which date the limitation has to be counted. That is the date on which the award is.
Suppose you will reply to this.
My lord, a short time will be given.
They want time. 4 weeks at least.
Otherwise, matter is covered by this Honorable Court decision.
Yes, they don't know it.
Well, this is an arbitration appeal lodged under section 37 lodged against the order passed under 34 lodged wherein the award has been set aside, Lord.
Award?
Lord, the arbitration award issued in my favor has been set aside, Lord. My lord, on the last date of hearing, my lord had summoned for the records, my lord, of the lower court as well as the arbitrator, my lord. My lord was pleased to grant me interim, my lord.
Award was in your favor.
My lord, award was in my favor.
To what extent?
My lord, to the extent, my lord, that they had issued an expulsion notice. My lord, there was a partnership firm. They had issued an expulsion notice saying that I have been expelled from the firm. The arbitrator held that to be illegal, my lord. My lord, that order was set aside by way of the award, and I was held to be a partner in the firm, and I was entitled for the for my share, my lord.
What is this IA1 for stay? 792.
My lord.
There is already an order to stay alienation.
My lord, there is, my lord. There is, my lord.
So copy hai na?
My lord, it has to be heard, my lord. That has to be
My lord, the award was in their favor and it has been set aside. So far as making a prayer for staying the order of the.
We will not stay it. There is
Yeah.
already an order to
Alienation, my lord, that was an undertaking given by us that held the disposal of the appeal. My lord, we are not alienating the property. Because the otherwise under 41(5) they cannot seek a section 9 relief before this honorable court. That's the section 9 powers in case if you wish to, but still, my lord, we have on our own conceded on the last date also, my lord.
That should be heard.
Yeah, it should be.
Third admit. Order extended until further order 791 accordingly disposed.
I'm grateful.
792.
Grateful.
Suppose file is IA for vacating.
Yes, sir.
Yes. Yes. Who is R3?
Yeah, I'm representing.
What is your ground for vacate?
My grounds are there. The appellant has not approached this honorable court with 3 night matters.
Huh?
They have suppressed certain facts. Firstly, that I am interstate senior to him. I was posted the post of homeopathic medical officer on 10/1/1990, and he was posted on the post of Ayurvedic medical officer on 2010-2011. So I'm 1 year senior to him. And secondly, his contention is that homeopathic medical officer is not eligible for the charge of the district high officer.
Against an interim order.
My lord.
Why don't you argue the matter there?
No, on the last date, my lords had heard us on this application itself. My lords had sought clarification from the government. It's a case, my lord, where against the rules, because my friend says that he is senior to me. There is no comparison in his and my seniority.
Why should we hear all that? It's an interim, interlocutory stage. Let the single judge decide to continue the interim order or not.
The interim order, my lord, was declined. Therefore, thereafter, my lords have passed an interim order in my favor. Now the charge is given to me.
Order includes the content.
My lords, that interim order may kindly be continued till the.
No, that will not continue.
Because the question, my lords may kindly see, contrary to the rules, my lord, this order was passed in my favor because, my lords may please see, as per the rules, she is not entitled, my lord, to hold the charge. She does not fall in the feeder cadre of that post. District Ayush officer. We had drawn the attention of your lordships to the rules.
Well, rules are concerned, my lord, his contention is also wrong.
Yes,
But he's saying that I'm not fit for the charge. Basically, it's a charge, number one. It's not a regular post, nor it's a promotion. So as charge is concerned, seniority is counted primarily. So I'm inter se senior to him. So secondly, he's saying that I'm not fit for that post. So if we see Schedule 3, Rule 8 of the Indian भारतीय चिकित्सा पद्धति तथा होम्योपैथिक राजपत्रित सेवा भर्ती नियम 1987 को अधिष्ठित करते हुए, so these are the basically 2013 appointment rules. So here the name of the post is जिला आयुष अधिकारी and विहित शैक्षणिक अर्हता मतलब educational requirements are विधि द्वारा स्थापित विश्वविद्यालय से आयुर्वेद यूनानी होम्योपैथी में CCI MCCH द्वारा मान्य स्नातक उपाधि. So homeopathy is also there. So the word actual Ayush is AYU is for Ayurvedic and U is for Unani and the last H is for homeopathy. So far as district Ayush officer is concerned, a person who is eligible, who is holding the degree of homeopathy, so he or she can be appointed for that post, appointed or promoted for that post. And so far as charge is concerned, charge can be given if a person is senior in his service. So far as point number 3 is concerned, she is inter se senior to him. That's why the charge was given. So that's our submission. And so far as diploma is concerned, his next allegation is that we are a diploma holder, and this the notification dated 13/3/1990. By Central Council of Homeopathy, it states that Annexure AR1. We filed an additional reply also. That is document number 2324/23.
Yes.
So this notification says that it has been written by the Secretary, Central Council of Homeopathy, to the Secretary, Government of India, Ministry of Health and FW, Nirman Bhavan, New Delhi. And subject is declaring 4 years course in homeopathy equivalent to degree. It says so. I am directed to
that
say.
Is the degree you have.
I am having the diploma, but this notification says that it has declared.
Have you seen this additional?
I have seen, my lord, this cannot be granted, my lord, as contrary to the rules.
So it says that, sir, I am directed to say that the Central Council of Homeopathy in its meeting held on 9th of March 1990.
Which page you are reading, Council?
I am reading page number 8 of additional reply. Page number 8, Annexure AR1. So the subject is declaring 4 years course in homeopathy equivalent to degree. I am directed to say that the Central Council of Homeopathy in its meeting held on 9th of March 1990 has decided that medical qualifications in homeopathy of having 4 years duration obtained after undergoing a course of study in homeopathy of not less than 4 years duration, like DMS, DHMS, LCEH, etc., awarded prior to enforcement of homeopathy diploma course regulations 1983 and included in the second schedule to the Homeopathy Central Council Act 1973 may be treated as equivalent to degree. So the next point is, I am a diploma holder. I have done 4.5 years of diploma. So I took admission in the year 1983. My diploma was completed in the year 1987. Now the point is, when
were these 83 regulations?
right. That is the main point, that when the homeopathy diploma course regulations 1983 got enforced in this state, in Madhya Pradesh, that the state will ask.
Government.
Short time, the OIC has been appointed in this case, and filed the reply. On the specific point, my lord, I'll take instruction.
पहले नहीं बोलते क्या आधे घंटा
Lord, the vacating stay was moved by the private respondent, my lord.
But is it regulations में नहीं होता क्या when it came into effect?
Sorry, pardon.
Do you have the copy of the regulation?
Yeah, regulation, madam.
This homeopathy diploma course regulation 83.
No, I do not have that.
Huh?
I don't have. And when they got enforced in this particular state, that we are searching for that.
Correct. If you get the rules, वहाँ भी रहता है ना when it was enforced, came into being.
That we are searching for, madam. We, respondent number 3 herself is searching for that from the department in which he is working.
All after 4 weeks, request of state in order to continue.
There is 107 days in delay in filing the appeal.
On the last date, the respondents sought time to file objections to not the order, and the challenge is at page number 13 of the appeal. Facts of the case are like this, not that the respondent writ petitioner was granted appointment on probation subject to police verification. On the declaration form, my lord, there was an entry whether you have been ever bound over or not. My lord, he said no. On that premises, my lord, his appointment was cancelled. Subsequently, he moved the writ petition, my lord. There was a direction to consider his case, my lord. So his representation was reconsidered, and having considered the entire aspect, not since there was willful suppression, the authority found him unfit for being in employment. Now, my lord, the Honorable Single Judge has again remanded the matter by setting aside both the orders, my lord, the cancellation of appointment order as well as the first rejection order, and has directed for consideration the light of Pawan Kumar's judgment. But my respectful submission, my lord, there has already been a reconsideration in the matter. The authority has assigned reasons, my lord. And Pawan Kumar is retaliation of Avatar Singh, which will not categorically laid down, not that it's the prerogative of the employer to judge the suitability. Now, reasons have been assigned, my lord, while rejecting his representation. Now, without adverting to those reasons, my lord, again a remand order has been made, and that too by setting aside the order of initial cancellation order is also now set aside.
Yes.
In fact, the reason for passing such order, Malit, has been mentioned in para 5 of the judgment.
Yes.
In fact, the allegation which has been made, Malit, that it has been suppressed. In fact, no offence has ever been registered against present petitioner. Rather, merely preventive measures has been taken under 107 and 16 of CRPC, Malit. In fact, it does not amount to suppression at all. And they are considering it to be a suppression. That has been considered, Malit, and therefore matter has been remitted back. Para 5 of the judgment, para 17 of the paper book may kindly be seen, Malit. In fact, there is no offence at all which has been ever registered against present petitioner, Malit. Rather, it was merely a preventive measure under 107 and 116 of CRPC was taken place. And in fact, present petitioner was not even aware about it. He has not executed any bond in that regard, Malit. If some offence has been registered, then only, Malit, that would be consideration. There's a specific finding given by the single bench, Malit, that it is not an even offence registered against present petitioner. Para 5 of the judgment may kindly be seen.
What was registered against you?
Malit, it's a preventive measure taken by an executive magistrate under 107 and 116 of CRPC. That's all.
What is that 107, 116?
Malit, it's a preventive measure where a bond can be executed by an executive magistrate, Malit, if they found that some offence may be committed by the petitioner. That's all, Malit.
Is that not a criminal matter?
No, Malit. No, in fact, no punitive measure has been given for that.
Yes, it shows the judgment on that one.
In fact, Malit, it is merely preventive measure. If Malit permits,
that is because you are a dangerous man. You are not very dangerous. You are little dangerous. That's why they passed it.
In fact, I have produced all these.
They would have lodged an FIR against you.
What happened, Malit, by this preventive measure has been taken against me, my lord.
Yeah.
That a dispute has been taken place by the brother of present applicant with the neighbors, my lord, on which, my lord, an offence of 323 has been registered against brother of the applicant, of the petitioner. And on that only, my lord, a preventive measure has been taken that a bond has been said to be executed. In fact, that bond has also not been executed. The only thing which has been stated, my lord, that you execute a bond that you would not involve any criminal activity. That is the only thing which has been there, my lord. I was not found involved in any of the criminal case at all. And that has been pointed out by Leonard Single Judge, my lord, that it has been stated it is not an offence at all, and it's merely a preventive measure which has been taken place.
Just brush away it like that on such a light footing. The fact that these orders are passed shows the.
In fact, my lord, if Mal permits me, I'll demonstrate all the measures which has been taken and the manner in which it is to be taken under CRPC. It is merely a notice issued by the executive magistrate where a bond is required to be executed that he will not involve in any criminal activity for further period of 6 months or 3 months, whatever. In fact, that notice has never been served to me. That finding is being given by the executive magistrate. And in fact, my lord, when this inquiry was made, my lord, inquiry specifically stated this proceeding is being taken place against me. I am a meritorious person, that is why I have been selected, my lord. And in fact, this is not an offence at all. I have not been found involved in any of the criminal activity by any of the.
What is the requirement in the form?
That I am required to execute a bond that I will not involve in any activity, criminal activity for further.
Which is that column which you are.
Page 21 of the writ petition. Column 12 below, down below. 3 questions were there, my lord. क्या आप कभी गिरफ्तार किए गए हैं? क्या आप पर कभी अभियोजन चला गया है? क्या अभी कभी आप निरुद्ध किए गए हैं या आपसे मुचलका लिया गया? Question was, my lord, whether you have ever been asked to execute a bond. So he said no.
No offence has ever been registered. Neither I have been taken into custody.
What is the requirement?
In fact, I was not executed a bond also.
What is the requirement of will? Well, what is the requirement?
Whether any bond has been taken from
or some jurmana has been, whether some fine has been
Were
imposed.
you asked to furnish a bond?
No, my lord, that's what my submission. I have never executed any bond.
So where is that 106 proceeding?
In fact, what it has been happened, my lord,
106 proceeding.
my lord, what happened, that proceeding has been initiated and it has been dropped. Even I have not executed any bond, my lord. I have not executed any bond, my lord.
Anything else?
Page 26 is the bond order.
Where is this order under 107, 116? Is there any order passed?
Page 26.
What does it say?
Lord, page 26. Lord, the number 4 is his name, Lord Parvat Singh. समस्त निवासी सो के विरुद्ध प्रस्तुत किया गया आवेदक अनावेदन के विरुद्ध सो को लेकर विवाद जिससे शांति भंग होने की तीव्र आशंका होना बताया गया है। थाना प्रभारी द्वारा प्रस्तुत इस्तिगासा का अवलोकन किया गया, प्रकरण दर्ज किया जावे। थाना प्रभारी द्वारा प्रस्तुत इस्तिगासा इस बात की पुष्टि है कि अनावेदक के मध्य विवाद है, शांति भंग होने की तीव्र आशंका है। अतः प्रारंभिक आदेश धारा 111 सीआरपीसी के तहत पारित किया जाता है कि अनावेदकगण कारण बताओ नोटिस जारी कर क्यों न 6 माह तक की अवधि के लिए शांति बनाए रखने हेतु 5000 की जमानत उतनी ही राशि का मुचलका बंद पत्र दिया जाए। Thereafter, my lord, the proceedings were not the issue is, my lord, whether he was ever bound over or not. This is the question. He said no, my lord.
What did he do after this?
My lord, in his reply, he says, my lord, that it was for a 6-month period and it expired after 6 months. His reply is at page 29.
No, he was asked to furnish a bond.
Bond.
Did he furnish a bond?
But that
Lord, as per his reply, my lord, he has furnished me.
No.
Show call. P7 may kindly be seen.
What does that say?
My lord, this says, my lord, कि महोदय जी से, मतलब लास्ट है, महोदय जी से न्यायालय के आदेशानुसार जो कि प्रकरण शांति बनाए रखने की कार्रवाई की गई थी, इसकी समय अवधि 6 महीने की होती है एवं 6 माह की समय अवधि के पश्चात प्रकरण समय समाप्त हो जाता है। चरित्र प्रमाण पत्र के अनुसार मुझ पर कोई आपराधिक प्रकरण थाना अहमदपुर में पंजीबद्ध नहीं है। इस प्रकरण की जानकारी पूर्व में मुझे पुलिस तथा न्यायालय के माध्यम से प्राप्त नहीं थी। अतः श्रीमान जी से निवेदन है कि माफ किया जाए। अतः महोदय जी से निवेदन है कि जानकारी का अवलोकन।
Before what date you are supposed to give a bond?
But this order is of 2013. Appointment is of 2015.
Bond for bond.
Well,
before what date?
Lord, the next date is of 18/3/2013. This notice itself says, my lord, पेशी तारीख 18/3/13. 18/3/2013 was the next date given by the SDMO. And thereafter the proceedings
the bond.
To furnish the bond.
If he does not furnish, what happens?
My lord, then he will be arrested and sent to jail.
He arrested.
But that material is not there, my lord. I am for the university, my lord, in this case. But the issue is only, my lord, that question was posed to him and he said yes. No, that is the, what is the effect, my lord? The effect is, my lord, that he has suppressed the material information from the employer. And therefore, he has been considered unfit. Bond नहीं देंगे तो he has to go to jail. No. Either he has to get this order set aside in a criminal division or he has to furnish a bond. There are only two options available.
They may be directed to make an inquiry if some bond is being executed by the petitioner. Malik, he has never executed a bond.
Worse for you.
I have never executed a bond.
That is even worse for you.
But effectively, these proceedings are merely a preventive measures, which is to be taken by the executive magistrate, where there is some apprehension of some involvement in a criminal activity. It is nothing more than that, Malit. In fact, what happened, Malit, a small offense a small scuffle took place between brother of the present petitioner.
You have told that earlier.
Malit. So what my submission?
Same brother. No?
Pardon, Malit?
Same brother.
No.
Scuffle with only one brother.
One brother.
Or another brother, another scuffle.
No.
Only one brother.
One
scuffle.
One brother.
That we have heard.
Malit. So effectively, what my submission is, Malit, present petitioner was even not aware about this proceeding, Malit. And the thing which has been taken place, Malit, what my submission is, if Malit see the circumstance, I have been selected, Malit, on merits, Malit. The thing which is being stated, whether the separation would affect in any manner.
For how many days?
Malit, I have worked.
But appointment is cancelled on 5/12/2015.
7 months.
Does it affect the character of the petitioner, Malit? It won't be. Effectively, he never.
To answer court question first.
Pardon.
How many days were you working?
But for around 6-7 months.
Then you were terminated.
Appointment cancelled.
Appointment has been cancelled.
So
a show cause notice has been given.
2015 to 22, you are out of job.
Mal.
Now suddenly you are going to get this job.
But this petition was pending before.
There was no interim order there. So you
no,
were out of service.
there was no interim.
You are out of service.
I was out.
When was that order served on him?
That bond order, but that material is not there. Roy does not have that material. Lord, he has been proceeded only on the material that in the police verification this information came. And column 12, the information submitted by him was found to be false. This declaration no given was found to be false, because there was specific query as regards mutual bond.
Why, what is your difficulty in reconsidering this? Why you filed writ of appeal?
Not reconsideration was already there. Once there was.
Do it again. One more writ will come.
Not the original order has also been set aside. Not that is also my difficulty.
Which one?
Not the original cancellation order. Now he has to be reinstated. There was a consideration in compliance of court order earlier. That order has been set aside, but the initial order, which was not set aside in the first writ petition, has also now been set aside.
What? 5/12/15. That's a termination order.
Termination order is also set.
And what is 14/10/16?
That is reconsideration order P10 at page 35, 36. I'm sorry. So reconsideration, my lord, if your lordship direct note, but that to that extent, lord, till reconsideration, lord, we may not be compelled to give effect to.
That will clarify.
Then
specific direction is being issued
to the same order. Just change the dates. Then
that will do, lord. We are primarily aggrieved by the restatement because the original order has been set aside.
Where is the reinstatement?
Lord, since the original order has been set aside, he has filed contempt without charging.
Contempt?
That is there before single judge.
Yes.
When they have not complied, there is a specific time fixed for 90 days. It may be reconsidered in the light of Pawan Kumar. That has been decided by honorable single bench one.
Counsel, delay in filing the appeal is controlled without a pass for the learned single judge setting aside the impugn order and directing the respondents to reconsider the case of the petitioner. The respondent therein is complete. The plea of the appellant hearing is that even though the matter is going to be reconsidered, in terms of the impugn order, the demand being made by the writ petitioner is for reinstatement. That a content petition number so and so has also been filed. That appropriate interference is called for. So far as remitting the case for reconsideration is concerned, we do not find any ground to interfere in the well-considered order passed by the learned single judge. However, in terms of para 6 of the order of the learned single judge, it does not imply reinstatement. Therefore, reinstatement of if any would arise only when the matter is reconsidered in favor of the writ petitioner and not otherwise.
Right.
Hence, we find no good ground to interfere with the appeal disposed of with the aforesaid observations.
Lord, may I pray for 60 days time, Lord, further to.
The time granted by the learned single judge is extended by a further period of 4 months from today.
What's a 1 day time may be given to file rejoinder?
What is it?
In fact, in this matter, they are seeking a direction that in the light of the judgment pronounced by the Honorable Supreme Court, state may be directed to frame terms and conditions of determination of tariff. So, my lord, our stand is that we have already taken care of the judgment pronounced by the Honorable Supreme Court, and accordingly, regulations are framed. Now, they want time to file rejoinder.
4 weeks to file rejoinder if any.
I'm sorry.
Lots of, we received the copy of reply on Friday.
What you?
4 weeks.
4 हफ्ते दिए और थोड़ा चाहिए?
No, sir, thank you very much.
I'm
48.
There are 5 cases, my lord. My lord has issued notices on 27/1
The government advocate has accepted notices, and my interim review has to be considered. They have not filed any return, my lord.
Government,
I pay for time.
4 weeks at the request of state.
My lord, my interim review may be considered, my lord.
No, for that only.
In one case, my lord has rejected also because the petitioner counsel has insisted. In my case, my lord has said of.
तो वही follow करेंगे ना.
On
कौन सा है
that,
देखो.
नहीं, उसमें my lord आपने इसलिए रिजेक्ट किया था कि उन्होंने इंसिस्ट कर
इसीलिए
दिया.
4 हफ्ते बोले ना, आप ही याद
नहीं,
दिला
मेरे
रहे
को
हो.
4 हफ्ते.
डिसमिस हुआ है, मेरा भी डिसमिस करो.
नहीं, मेरा 4 हफ्ते में हो चुका था.
तो फिर चुप के जाना ना. तो वही फॉलो कर सकते हैं. नहीं?
You, I have got notice, my lord.
We are aware. We are aware of all your 15-year-old cases.
This I'm humbly praying for a week's time to argue the matter.
Why?
Well, I am relying upon few judgments, which I just went through those judgments, my lord.
No, please argue. We are not going
My lord, in fact, the very issue I would like to address would be the maintainability.
Yes,
and this is the reason, my lord, I'm praying for
No, please argue. What is this case?
Because the case is like this, my lord, that we are aggrieved by the order passed by the tribunal. Now, by the DRT, my lord. Now, my lords, by way of the impugned order, my 3 applications had been decided.
Which order you are?
P1 is the order, impugned order. P1.
Passed by whom?
The DRT, my lords. I am aggrieved by this order only to the extent, the way and the manner in which my SCA application has been decided. Now, my lords may appreciate.
Writ is maintainable.
This is the reason I am praying for next week, my lords. Few judgments I have relied upon. There is a direct judgment.
You give it right now. We are not.
No, I'll just have to take out.
We are not giving.
My lords, only in the interest of justice to address on the point of.
In the interest of justice, we can't waste public time.
My lords may have.
Not at your convenience that we are going to adjust it.
No.
And interest of justice is not going to save you. You are doing gross injustice in the court by taking a judge.
I'll just demonstrate, my lords.
It's your case. Why can't you get ready? You can't understand this. It is your case.
Yes, ma'am.
This is not the first day.
Yes, ma'am.
Again you want. Why should we get it listed? If you're not interested, please tell us. We will remove this matter from the list.
No, my lords.
Can't they just list it for us to sit here and keep granting adjournment? February 23, you have been taking time.
Last time due to
20th February, you took time.
No.
23rd of February, you took time. Again, you are taking time. If you're not interested, you don't leave it for concept. You don't file cases.
No, my lords.
You can't file a case and then go do research.
No, it's already done, my lords.
We are sure your senior has not taught you like this.
It's already done, my lords. Research is already done.
Yes, what do you want now?
My lords, my only submission is, my lords, that the way and the manner in which that particular condition has been imposed upon me, that is not proper. My lords may appreciate the fact my stay matter was listed on my stay application.
Yes.
Now, the learned tribunal, my lords, neither allowed my application nor rejected my application.
Yes.
It has simply disposed of the application, my lords.
Ah.
Despite the fact that para 21 there was a specific finding in my favor. And this is my grievance. That either at that stage, tribunal could have allowed my application or could have rejected it. But without and keeping the everything open for the final hearing, learned tribunal only imposed the condition. That's the point of grievance.
Tell us how a writ is maintainable.
I'll just point out, my lords. My lords, there's a judgment of Honorable Division Bench of Karnataka High Court on the point
We
whether.
are not bound by Karnataka.
My lords, that got affirmed. This is what I am submitting.
Show the Supreme Court judgment.
My lords.
It's not affirmed. SLP dismissed is not affirmation.
I'll point out.
Affirmation is different. Affirmations are not.
My lords, in view of doctrine of merger, my lords, once the order, I'll demonstrate from 2006 SCC.
Start the demonstration.
This is the compilation. Now, my lords, there are matters, my lords, where petition got dismissed. Now, my lords, my submission is by way of this short note, which was pointed out by this honorable court only. Now, honorable court pointed out a very first judgment, my lords, by which a similar kind of petition got dismissed. Now, my lords, I have tried to distinguish that case. The very first case, my lords, would find at page number 5 of the compilation. On the basis of 2019 Supreme Court, it got dismissed. One of the petition got dismissed. Now, all those cases where Honorable Apex Court has deprecated the practice of Honorable High Court entertaining 226 was at a stage where the proceedings were either at the stage of 13.4 or 13.2 or at the rejection of the representation under 13.3a. Now, here is a case, my lords, I am alleging that there is a lack of exercise of jurisdiction by the tribunal. In as much as, my lords, the tribunal had the jurisdiction to either allow the application or to reject. But tribunal only disposed of the application. My lords may come to para 21 of the impugned order. There was a categorical, my submission at this stage is, my lords, there was an auction got withdrawn. The very.
They asked you how were it appellate tribunal.
Yes, my lords.
You first tell us.
Yes, my lords may come to page number, my lords, 42 of this compilation. There were 3 issues which were framed by the Honorable Division Bench. The second issue was whether writ petition was maintainable without filing the appeal to the appellate authority as provided under section 18 of the Act. This was the very issue. Now, my lords would come to, in this particular judgment, para number 21. The contention of the respondents that under section 18 of the SURFACI, the appellant is required to file an appeal.
This is Karnataka High Court.
This is Karnataka High Court.
How it is binding on us?
I'll just point out. Now, against this judgment, there was an appeal filed before the Honorable Apex Court.
Yes.
This judgment is 62 page. My lords may come to 62. The very first paragraph, the leave was granted. Page 62. This is 2014-5. This very Karnataka High Court judgment got challenged, was subject matter of this.
Yes.
Page 62, my lords would find thereafter, my lords may come to very first paragraph of this judgment. Page 67. Page 67, right at the top, my lords would find that leave was granted. Now, my submission is once the leave was granted, the doctrine of merger would be applicable.
Which is relevant para?
The relevant para is, my lords may come to 27, by which the appeal got dismissed, meaning thereby the High Court of.
Where is the finding with regard to maintaining of a writ petition?
No, that is not there in all fairness, I say. But my submission is in view of Qayyum Muhammad, my lords, in view of doctrine of merger. Just because the.
You a simple question. Say that you in 226 and not go to the appellate tribunal.
That particular issue was decided by the Honorable Division Bench of the Karnataka High Court. That got affirmed in the appeal before the Honorable Apex Court. Thereafter, my lords, 81 page. 81 page. This is a judgment on the point of doctrine of merger. Now, this says, I'll just read out, my lords, para 41, my lords may see.
We are aware of this, Punam.
Yes. So, just the 2 conditions which would cover my case. So, just because my case is, my lords, the leave was granted. There was appellate jurisdiction assumed by the court, my lords. Yes. So, in view of this, my lords,
we'll consider that point.
This is how, my lords, I submit that.
What is the order passed by the tribunal?
Tribunal's order is, my lords, that you have to pay this amount. Some condition has been imposed. My only concern is, my lords, there was a finding in my favor. Para 21, my lords would appreciate in the impugned order. Para 21 specifically says that there was a finding in my favor. When at this stage, my submission is when there is a prima facie view in my favor. In that case, either tribunal could have allowed my application or could have rejected. But tribunal only, despite the fact there was a finding in my favor, tribunal order was, my lord,
pay 20 lakh and auction will be stayed.
Stayed. That's the order.
Did you pay?
That was still on 23.
Did you pay or no?
No. The last date is.
When is the date of auction?
auction was, my lords, in fact, as per them, the bidders have already come. So, because this was sometime in October 22, the bidder was supposed to pay.
Time of the 20th February to pay.
20th of March, the second installment. The first was supposed to be paid by 20th of February.
Have you paid it?
As on date, just because we approached this honorable court, we did not pay. And the second installment would be on 20th of March.
Second will not arise because first is not paid.
In case I pay the 20 lakhs, my lords, because 20th 3 is the date on which I was supposed to pay 20 lakhs.
Left to you for your understanding.
By the order.
As far as we feel, the second installment comes into play only when the first is paid. You can't go to the second step without clearing the first step. But we still can't understand your argument that the tribunal could not have passed such an order, even assuming looking into it. When it drafts a conditional order of stay, you are agreed by it. Ultimately, you are trying to say a stay application must be allowed totally or totally dismissed. Sum and substance of your argument is that. Is that correct? Huh?
Yes.
ये condition नहीं डालना.
Because the only reason is.
1 second.
Yes, yes.
Is that your submission? Have we understood you clearly? So I say when an IA for stay is granted, या तो stay दे दो, नहीं तो dismiss. ये sympathy दिखाने का जरूरत नहीं पड़ता है. That's your argument.
In view of para 21 of the impugned order.
In view of anything in this world, they have granted you some kind of relief because you cannot pay 40 lakhs. They have said, all right, you pay 10 now, 10 now, 10 now. Some kind of a equity jurisdiction has been exercised. That is wrong. That is your case.
Well, only in terms of para 21 of the order.
That's why I said we can't understand it. It may be para 21, it may be 21 paragraphs also.
If my lords may appreciate.
Even then it's a discretion of the authority.
I'm not on
that. Exercise in your favor. Yes. And you're agreed by it. And you're saying you're protected by Supreme Court. You don't know how you're linking 1 to 1 to 1 to 1. It's a very long, short argument.
Fact, as a matter of fact, the bank was relying upon an auction which was already withdrawn. That were the facts of the matter. And this is the reason.
Counsel, isn't an interim order discretionary?
Absolutely. In view of Madhya.
Mold interim
My
order.
lords.
We had interim order even by an oral request made by the party. Don't we grant it? Then?
I'll withdraw this.
No. You have taken so much time. You must have earned an order. I simply refer to the judgment.
Obliged.
Some judgment of Supreme Court.
आपका भी है?
And for this parliament. In which the Honorable Supreme Court has
judgments
when the alternate.
कितने judgments हैं?
3 है हमारे. 2 Madhya Pradesh
उनका 3 है.
मेरे साथ
3.
4 judgments हैं.
तो और एक लेके right on. Liख दो respondents.
Obliged.
We'll consider the context.
Obliged.
Okay.
Where is the respondent?
Sir, I am.
What is your name?
Manoj Kumar Pirwal.
Manoj Kumar. Have you filed any reply?
Yes, sir. I have already filed reply.
Already. You are for whom? Huh? The accused is present. Hereby deem it just and necessary to request Sri Pushpendra Yadav to act as amicus curiae to assist the court in the disposal of this petition. Registry to furnish a copy, all the papers to him by next day.
सर से इन्होंने 11 मार्च 13 का ऑर्डर आज तक पालन नहीं किया है.
एक मिनट कॉल ऑन. March.
पहले मेरी रिक्वेस्ट सुनिए.
बोलिए.
ये 11 मार्च का जो ऑर्डर पड़ा था ऑनरेबल कोर्ट का, इन्होंने आज तक उसका पालन नहीं किया.
11
मार्च 2013. दूसरी बात है, ऑनरेबल हाई कोर्ट से मेरी 2 पिटीशन गायब है, चोरी चली गई है.
ये 7 केस है आपके ऊपर.
मेरे को तो 5 के ही वारंट दिए थे, 2 के आज तक नहीं दिए.
हाँ,
2 वारंट तो आज तक नहीं दिए मेरे को.
2
मेरे को नहीं पता.
ये 3 और 4 का.
जी
ठीक, डायरेक्शन देंगे.
बट लॉर्डशिप मेरा कहना ये है कि ये तो खुद ऑनरेबल कोर्ट के ऑर्डर को मान ही नहीं रहे और मेरे को बुलाया जा रहा है.
अभी आए, अभी बताया ना, तो अब डायरेक्शन करेंगे देने के लिए.
नहीं, ऑलरेडी एक बार हो चुका था.
13/11/3 का
हो चुका था.
हाँ,
वो भी हो चुका था. उसके बाद भी कंप्लाई नहीं किया.
the registry to furnish all necessary papers on contempt CR 3 of 13 and 4 of 13. The accused herein in terms of the order dated 11/3/2013 by next date.
लॉर्डशिप कंटेम्प्ट जो 6 नंबर मेरे पे लगाई है, उसका पेज नंबर 14 पे मेरे खिलाफ कुछ लिखा हुआ है. वो भी सारे दस्तावेज मुझे चाहिए. वो ऑनरेबल कोर्ट के ऑफिस ने लिखे करीब 80-200 पेज.
देखेंगे नेक्स्ट डे.
लॉर्डशिप मेरे को रिप्लाई देना है, फिर मेरे को बहुत मुश्किल होती है.
आपको जो भी पेपर्स चाहते हैं अप्लाई नहीं कर सकते.
मेरा आवेदन ही नहीं लेते.
इसीलिए ना, जब वो सुनेंगे तब जरूरत पड़ेगा तो देंगे आप.
लॉर्डशिप मेरी एक और रिक्वेस्ट.
आपको हक से मांग रहे हैं तो एप्लीकेशन डाल दीजिए, मिलेगा.
एक रिक्वेस्ट है मेरी. लॉर्डशिप वो हक से जो बात मैंने मांगी थी, मेरी पिटीशन ने चोरी करवा दी है. ऑनरेबल कोर्ट से पिटीशन चोरी हो चुकी है. पिटीशन नंबर है 8 CONC 8/2013. वो ऑनरेबल हाई कोर्ट से गायब है. कैसे गायब मेरे को नहीं पता.
नहीं,
कोर्ट से गई. फिर इंदौर हाई कोर्ट से भी मेरी एक पिटीशन गायब.
आज आर्गुमेंट कर रहे हैं आप.
नहीं लॉर्डशिप, ये पेपर मेरे को चाहिए तो मैं रिप्लाई कैसे सबमिट करूंगा. पेपर नहीं मिलेंगे मेरे को तो. मेरा रिक्वेस्ट ये है आप
जितने में रिप्लाई है वो डाल दीजिए, बाकी का नहीं है तो जो करना है हम करेंगे.
हाँ लॉर्डशिप, एक और बात है.
पेपर्स नहीं है तो कुछ नहीं कर सकते ना.
फिर मेरे को डिफेंस देता.
हाँ,
मैं डिफेंड करना है मेरे को अपने आप.
हाँ, इसीलिए वो अभी वो एडवोकेट अपॉइंट किया ना, उनको भी सुनेंगे, फिर
लॉर्डशिप इसमें एक छोटी सी रिक्वेस्ट और है, पेज नंबर कंपाइल्ड बुक के 93 और 92, 92 एंड 93, ये फर्जी प्रमाण पत्र लगे हुए हैं और सरकारी वकील इनको सपोर्ट कर रहा है। ये फर्जी सर्टिफिकेट है।
वो सब ट्रायल में सुने,
मगर जो एक्चुअल क्रिमिनल है वो तो एंजॉय कर रहा है और मैं पनिश हो रहा हूँ।
वो देखेंगे असली क्रिमिनल कौन।
ये मैंने सबमिट है लॉर्डशिप में।
ठीक।
और यदि मैं तो फांसी पे भी चढ़ने के लिए तैयार हूँ, क्योंकि ये फर्जी प्रमाण पत्र 1000 बार
हुआ सुन के वो पढ़ेंगे क्या है फाइल में, फिर डिसीजन लेंगे।
दूसरा, इन्होंने मेरे को कुछ दस्तावेज दिए, वो दिख ही नहीं रहे कि उनमें लिखा क्या है।
आप फिर से शुरू कर रहे हैं। अगर आज आर्ग्यूमेंट कर रहे हैं, हमें कोई दिक्कत नहीं, आज ही फैसला दे देंगे, ऐसा नहीं होता। तो उसको अपॉइंट किए हैं, वो देखेंगे फाइल में क्या है, फिर अगला स्टेप लेंगे क्या करना है, क्योंकि ये 2013 से है ना।
यस सर।
तो इतना जल्दी खत्म हुआ तो अच्छा रहता।
ये एप्लीकेशन
नेक्स्ट डेट दे
लॉर्डशिप, ये कंपलसरी है, क्योंकि मैं तो बहुत परेशान हूँ। तो फिर ये एप्लीकेशन लेके तो पुलिस तो मेरे को पकड़ने आ जाएगी।
क्या एप्लीकेशन?
आइए फाइल कर रहा हूँ।
क्या है
ये सेक्शन 39 सीआरपीसी, जो अपराधियों मैंने इनके नाम दिया उस रिकॉर्ड पे ले लें हम लोग। ये सीआरपीसी 39, उसमें ऑनरेबल कोर्ट को बताना है कि अपराध क्या हुआ और अपराधी कौन है।
जो कुछ फाइल करना है रजिस्ट्री में फाइल कीजिए
वहां पे। अच्छा, मेरी एक और रिक्वेस्ट है कि आज, चूंकि आजकल ऑनलाइन चल रहा है, मैं इंदौर से आता हूँ, तो ऑनलाइन सुनवाई कर ली जाए ताकि मेरे को इंदौर ध्यान नहीं आना पड़े।
60 इयर्स होना है। आप कितने उम्र है उतना नहीं लगता।
सर कल ही खत्म हो जाए, कोई रास्ते में मेरे को मार देगा, क्योंकि मैं बड़े लोगों के खिलाफ लड़ रहा हूँ, कोई छोटे मोटे लोगों के खिलाफ नहीं लड़ रहा हूँ। राहुल गांधी सब ये ने फर्जी अपॉइंटमेंट करे, वो सब मैंने उजागर करे हुए, तो कोई भी रास्ते में मारेगा मेरे को।
नहीं, मध्य प्रदेश में ऐसा नहीं, बता देंगे आपको, बोल दो केस के लिए 29th March accused to be present to show the name of Shri so and so.
Lordship, in this case, in item number 50, Lordship, I moved a temporary will application of the applicant. His father is died, Lordship.
51.
50, item number 50.
51.
अच्छा, sorry, 51. 51.
50. हाँ, वही want temporary bill.
Father died on Lordship 12/2/2022.
So what has to be done?
For attending the 40वां procession.
हाँ?
40वां ceremony for attending the 40वां
Why you
ceremony.
have to attend it?
21/2.
Why you have to attend it?
21/2/23 को होना है सर।
डेट नहीं पूछ रहे हैं, क्यों अटेंड करना है? What is the case against you? 302.
302
कितने लोगों को मारे?
सिंगल पर्सन।
सिंगल को, तो उनका भी परिवार होते हैं ना
लॉर्डशिप,
उनका भी क्या ये 40वां 30वां चलता रहता है ना, तो आपको क्यों
जनरल
करने के लिए
प्रेजेंस रहती फैमिली मेंबर, इसलिए सर 13वीं क्वेश्चन में
कितने मेंबर्स है फैमिली में?
फैमिली में हमारे 2 भाई और हैं, हमारे मदर है।
वो कर देंगे स्पेशल ग्राउंड।
मेन एप्लीकेशन भी पेंडिंग है सर, उसका जवाब नहीं।
कन्विक्टेड, यू हैव टेकन अवे समबडीज लाइफ, किसी और का जिंदगी खत्म कर दिया, तो अब आपको ठीक नहीं लगता?
Lordship, in so many cases, this honorable court has released the persons to attend the 13वीं occasion.
So many cases we have dismissed it all. Not a sympathy factor counsel, it's whether you deserve it. 13वीं होती है, शादी होती है, चौथी होती है, वो होता रहता है जो जिंदगी में। इसका मतलब ये नहीं कि हर एक बार छोड़ा जाए। Not when you have committed an offense of murder, counsel.
Regular application is also pending, Lordship.
Here that also, please argue. Please argue. दोनों आर्ग्यूमेंट कीजिए।
Objection is awaited, Lordship.
ठीक। This is ये temporary bail उसका application number
4848/23.
4848 is filed by so and so seeking for grant of temporary bail.
Only short period of 20 days has been.
You have written 40 days procession.
Lordship, it is a ceremony, Lordship. Due to mistake, it has been typographical error.
Okay, okay. But what is the actual reason?
Actual reason is that 40वें का जो फातिहा होती है 40 दिन में मुस्लिम कम्युनिटी के हिसाब से उसमें हमको पार्ट है. As per Hindu custom, 13वीं is organized, Lordship. As per Muslim custom, 40 days ceremony is to be organized after.
So how many days is the ceremony?
Only 1 day, Lordship.
On what day is it?
सिर्फ ये 21 तारीख को होना है. ये कार्ड लगाया हुआ है सर हमने.
Then why are you asking bail for 20 days?
As this honorable court deemed fit, may pass the order for 2 days or 3 days, Lordship.
It is not some joke.
Lordship.
When you file an application, there must be some seriousness involved. Why do you ask for 20 days? मजाक हो जाता है क्या? जो चाहे लिख लो, 20 दिन, 40 दिन, 50 दिन. आपको चाहते कितने दिन?
7 days का दिन.
तो ये 20 क्यों लिखते हैं? तो बार्गेनिंग का बात है क्या? Surprise how casual you can be in such matters. Yes, what do you say?
We'll have to call for the report to verify the genuinity of the claim. On 21st of March, he is saying that the 21st of March, the ceremony is scheduled to be organized.
Where is the death certificate?
That is there along with his application. D1.
Page 4.
Let him attend for that 1 day. Subject to payment of police charges. You take him in custody and to deposit in advance. State.
Note.
Is an application seeking for grant of temporary bail on the ground that the 40-day death rituals of the father of the appellant is to be held on 21/3/2020. The considered view that with the fact that his father, as stated by him, his father died on 12th February 2023, and the what is this program?
Chahallam.
Chahallam is to be held on 21/3. Direct the concerned police to escort the appellant for the said ceremony and take him back into custody for 21/3/2023. For this purpose, the appellant to deposit the sum towards the expenses incurred by the police towards such an exercise. Application disposed of accordingly. Yes, what about the main matter?
Objection is awaited if this non court.
Appellant counsel submits that he will argue this application only after receipt of objections. Hence, call after 4 weeks. This is 51, huh?
No.
Point 1 is also.
Point 1.
The objections are awaited.
Objection is awaited. Objection is awaited on the IE.
Appellant counsel submits that he will argue the matter only after receipt of the objection. Hence, call after 4 weeks.
51.2, my lord, the sentence has been suspended on 28/8/18.
No further order. No further order.
No further.
Yes, go ahead. Additional action allowed for 8 weeks.
Petitioner before a lordship is Ayurveda College, my lord. Seats remaining unfilled after the NEET candidates take examination. My lord, P9 at 237, my lord.
Huh?
P9 at 237 is the order, my lord, on identical Ayurveda College.
Government
237 page.
237.
Please, Your
Previous date, my lords were pleased to pass the interim order in this case, my lord. And my lords have restrained the respondent number 6 from holding the post. My lords, I'm praying for some more time to file the reply to this list.
Your Lordship, I have filed the recalling application for recalling order dated 14 Feb 2023, Your Lordship.
Yes.
Your Lordship, as per the last order, the Honorable Court has filed regarding the 10 marks, how the respondent number 6 got the 10 marks without submitting the relevant document as per the Honorable Court. Your Lordship, before I state my submission, Your Lordship, I just want to state the facts of the case in 2 minutes, Your Lordship.
Yes.
Respondent number 6 and petitioner has applied for the post of the Anganwadi worker, Your Lordship. And in this merit list was prepared, where respondent number 6, I got as a first rank and petitioner got the second rank, Your Lordship. Agreed by this merit list, the petitioner approached the additional collector, filing an appeal before the additional collector. Your Lordship, before the additional collector, there were 3 points raised before him. Number 1, the 10 marks of BPL. Number 2, the 6 marks of the experience. Number 3, the residence of the respondent number 6, which was questioned. Your Lordship, referring to the page number 22 of the writ appeal, is the order of the additional collector, where the additional collector has only dealt with the 10 marks of BPL. He has not dealt with the 6 marks of experience and the residence issue. And Your Lordship, against this order, the respondent number 6 has filed an appeal before the commissioner. Your Lordship, referring to the commissioner order on page number 13, the commissioner has regarding the 10 marks issue, it was raised, appeal was filed. Page number 13, Your Lordship, of the writ appeal. May I read the relevant para?
Yeah.
अभय पक्ष के विद्वान अधिवक्ता गण द्वारा प्रस्तुत तर्क के आधार पर मेरे द्वारा प्रकरण.
On what ground was the interim order granted? Have you seen the interim order?
Yes, Your Lordship, I have seen. The order was because the 10 marks were granted on the Samag ID, which was submitted after the time period. Your Lordship, I'm answering all the query. Lordship, in this order, the commissioner has stated this. May I read, Your Lordship, on page number 30. अभिपक्ष के विद्वान अधिवक्ता गण द्वारा प्रस्तुत तर्क के आधार पर मेरे द्वारा प्रकरण का अवलोकन करने पर पाया गया कि अपीलार्थी द्वारा उक्त पद वावद जो आवेदन पत्र जमा किया गया था, उक्त आवेदन पत्र के साथ बीपीएल कार्ड प्रस्तुत किया गया. Your Lordship, the BPL card was presented. अपीलार्थी द्वारा अपने आवेदन पत्र के कॉलम नंबर 7. Now, Your Lordship, I request the Honorable Court to refer page number 15.
Have you submitted this Samagra ID or no?
No, Your Lordship. That's the clarification.
For 10 marks you have been given for what?
BPL card of my husband. Basically, Your Lordship, as per circular dated 10/7/2017 of the MP government, which is, I mentioned my reply also, Your Lordship, the same Madhya Pradesh Government Women Child Development Department. In my recalling application, Your Lordship, There's a circular listed.
Yes, Mr.
Lordship. Lordship, there is an order passed with the additional collector, Lordship, page 22.
No, she's saying I did not even give Samagra ID. Have you seen her IA?
Lordship.
This IA for vacating, have you read it? Recalling.
No, Lordship, I am filed the vacating.
Your Lordship.
Have you given him copy of
Yes,
it?
Your Lordship, I have some.
He's saying that she has not submitted the Samagra ID only.
Lordship, that the issuing on only on Lordship two ground there this appeal, Lordship. First ground, Lordship, ki respondent thoughting भी है column number 10. We also remark कि हमारे पास कोई अनुभव प्रमाण पत्र नहीं है. Then भी 6 mark भी obtain. अगर इनको 10 नंबर जोड़ भी दिया जाए तो भी ये 6 नंबर से पीछे हो जाए, 6 नंबर इनका माइनस होगा तो हम ऊपर 1 नंबर पे आ जाएंगे.
Your Lordship, to answer that.
To file reply.
Your Lordship. Small submission, Your Lordship.
1 minute, please. Yes, please.
Your Lordship, I request the bench to refer page number 14 of the writ appeal.
We need some clarification from the government with regard to the 6 months.
Yes, Your Lordship.
What he's saying is that even if they give you 10 marks, if they give him 6 marks, he will become number 1. So that factual aspect, they have to clarify.
And I agree, Your Lordship. Only one point, I'm not denying anything. This writ petition was dismissed. The ground I'm stating, page number 14 of the...
No, we understand that. That is why we...
It was never raised before any court, Your Lordship. Before the additional collectors were raised but never dealt. Before commission was not raised. And writ appeal directly without mentioning on the grounds and the facts they have raised before the Honorable Court.
Correct. Anyway, it is there now. So once the records come, we will look into everything. Whatever in your favor, his favor, we'll consider everything and pass it. So because your grounds are different, his grounds are different. So that some clarification, maybe if the government gives it, it will be easy for us to
Your Lordship, the stay
find a solution for that.
The stay can be
We
vacated.
have to wait for some time.
Please, Your Lordship.
Granted, next date will dispose.
Lord.
You please bring it by next date. Because we have stayed our appointment also. No?
4 weeks.
We should not keep it pending.
Your Lordship, at least...
All after 4 weeks at request of stay.
Your Lordship, at least...
Also to procure the
original records.
Please allow her to work, Your Lordship. Respond.
Wait for 4 weeks, then we will dispose of that.
When matters pertains to the admission of 12 students in the master's course, whereby the university has not granted permission. Thereafter, my lord so pleased to direct them to open the link. The link was open and we have submitted the form. Now, thereafter, my lord, the query was asked by this honorable court on the last date of 16/2/2023, my lord, that why you are not passing any order. Now, they have, along in the reply, they have not filed any order. Now, by way of additional document, they are saying that in month of 6/2022, we have rejected the admission of all the students on the ground, on the presumption and assumptions that the documents are doubt. Now, that document is filed with covering memo on 23rd.
So what is to be done now?
My submission either
correct, we understand, counsel, but what can we do now?
Because this order, liberty may be
granted.
granted.
To challenge
Liberty may be granted.
Liberty क्या तुम्हारा हक बनता है?
I don't want to, by way of amendment.
Petition is dismissed with liberty to challenge the order dated
26/22.
Issued by
University.
In accordance with it.
I am grateful.
Lordship, I have not stated one point in item number 54 that the petition.
You make all your points together.
Sorry.
Next time you hammer it.
Lordship, petitions are approaching for the particular post, Your Lordship.
Counsel, we are looking into the entire file next date.
Immediate.
Whether ground is there or not, don't worry about it. We will go through everything.
Lordship, this matter is regarding the permissibility of the, this matter is regarding the admissibility of the input tax credit to the respondent number 6, respondent number 5, Your Lordship.
The petition is a works contractor, Lordship. The works contract order was ordered by the respondent number 5, Your Lordship. Lordship, we had supplied them the services, we had issued them the GST invoices in the month of March 2000.
What is the implement order?
Lordship, Annexure P1, Your Lordship.
What is that?
Lordship, it is regarding the clarification that the respondent number 5.
What is the order passed against you?
It's just a representation.
It is a representation order, Your Lordships.
There is no statutory order.
It is not a statutory order, Your Lordship. It is a this order has been passed on the basis of the representation filed by us, Your Lordships. Lordships,
what does the order indicate?
Lordships, the order indicated the respondent number 5 is not entitled
to consider representation.
Lordships.
What does it indicate?
It indicates, Your Lordship, that the respondent number 5 is not entitled to claim the input tax credit on the basis of the invoices issued by the petitioner on the grounds that the petitioner has filed a GSTR1 return belatedly in the month of December 2021, Your Lordships. So, Lordships, in view of the provision of section 16 subsection 4, which was been amended with effect from the 1st of January 2022, the adjudicating authority, that is the respondent number 4, cannot permit the respondent number 5 to claim the input tax credit, Your Lordships, on the basis of the invoices issued.
Where is the demand for payment?
Lordship, we had filed the GST 3B return, Your Lordship. It's Annexure P5, Your Lordship, page 36. It is not a demand, Your Lordship. We had issued the invoices. We had filed the GST returns, Your Lordships. In the two returns have to be filed, Your Lordship, GST1 return and GST 3B return. This matter is regarding for the month of March 2021, Your Lordships. We had filed the GST 3B return on 13th May 2021. And, Your Lordship, we had filed the GST1 return on the month of December 2021. Lordship, the amendment has been carried out in section 16, subsection 4. Lordship, by way of the amendment, Finance Act amendment.
You are making all the GST payment?
Yes, Lordships. We are the works contractor, Lordships, and we are making the payment to the GST department, your Lordship, and we are issuing the invoices to the respondent number 5. Lordship, in accordance with the section 16, Lordship, the respondent number 5, that is the service recipient, is entitled to take the input tax credit on the basis of the GST charged by us from respondent number 5 and deposit it to the GST department, Your Lordships. This is the smooth flow of input tax credit under the GST regime, Your Lordships. For that particular purpose, Your Lordship, we have to file two GST returns. One is GSTR1 return in accordance with section 37, and second is GST 3B return in accordance with the section 39. Lordship, this we had issued certain invoices in the month of March 2021. The invoices, Your Lordships, are Annexure P4, Your Lordships, wherein we had charged GST from the respondent number 5. Lordship, we had deposited the GST amount to the GST department while filing the GST 3B return in the month of May 2021. Lordships, now we had filed the GSTR1 return indicating the bill-wise details in the month of December 2021.
What is your grievance, counsel?
Lordship, my grievance is that, Your Lordship, since the respondent number 5 is not entitled to take the input tax credit, so Lordship, he is not reimbursing us the GST amount which we had charged from them and deposited to the GST department.
All right.
This is the only grievance, Your Lordships, and now they had started deducting the GST amount from our running bills, Your Lordships.
How are the writ court concerned with you?
Lordships, the writ court, Lordships, on the grounds, Your Lordship.
No the remedy for you?
No, Lordships. Even, Your Lordship, we cannot file the appeal against this order, Your Lordship, because this order has not been passed.
Who is for R5?
Lordship, no one is appearing for R5.
That's it.
No, I appear for the GST 1, 2, and 4.
1, 2, 3.
1, 2, and 4. No, 3 is the state. That's the commercial state.
Where is R5?
R5 is not.
R5 is not appearing.
They are the one who's contesting.
Yes, yes, Lordship.
Take out notice on them then.
We have served them the advance copy.
Notice or what? List on so and so by showing the name of Siddharth Seth. ऐसा नहीं है. But to take out notice on R5.
Lordship.
Huh?
Lordship.
So what is your urgency now?
Lordship, they started deducting the GST amount from our.
कितना होता है?
It's around 1 crore, Your Lordships.
That's all. What? क्या business करता है?
Lordship, we are the works contractor, Lord, we are constructing the railway bridges.
How much is the turnover?
54 crores, Your Lordship.
54?
Crores, Your Lordship.
Then 1 crore क्या? कोई कोने में चले सब.
Lordship, but we have to make the labor payment, everything, Your Lordship.
Issue notice to?
R5, Your Lordship.
Issue reissue notice to R.
Okay, Lordship. Okay, Lordship.
Praying for next week. Praying for next week.
Why?
Lordship, केस लिस्टिंग की जानकारी आज लगी सीनियर आउट ऑफ स्पेशल. केस लिस्ट आज हुआ है सर. लिस्टिंग की जानकारी आज.
परसों में आया था ना.
लॉर्डशिप
counsel 6 times, follow to 4 weeks.
Mr. Madhu Shukla appears for EOW, which is the contesting respondent. His name is.
Let him argue his case.
This case, certain directions were given by the Honorable Court on 20th of February. I just wait for 3 days time to file my response. The instructions have come orally, madam. I want to put it on affidavit.
Respondent counsel 6 times, follow after 2 weeks. The order extended till then.
Pleasure.
Denied.
My lords, we just take up order sheet number 5-1, dated 5-1-2023, my lords. This honorable court had directed the counsel for the CBI, my lords, to find out whether the charge sheet has been filed in the case or no.
What is this matter?
My lords, this is a 482, my lords, where the
482.
My lords, subsequent FIR, my lords, on the same facts and grounds by the same complainant has been registered by the CBI. And my lords, initially the first FIR was already registered by the local police station. So, my lords, we are before my lords that a subsequent FIR on the same facts by the same complainant would not survive. So, if my lords will just.
Why are there 2 cases?
My lords, in their reply, they say because we were not aware that the initial FIR has already been registered, so we registered. My lords, the counsel for the CBI would be the person to answer that.
Why CBI?
Mr. Vikram Singh appears, my lords, have.
So you have challenged both the FIR?
Only the subsequent FIR with the CBI. We are
What is the connected case?
My lords, there are 2 accused, my lords. They have preferred 2 different 482s in the FIR. One is Mr. Pramod Sharma and the other is Mr. Vijay Changwani. So rather than filing one 482,
final report is filed in which FIR?
In the FIR where the CBI was investigating the subsequent FIR. Second one.
First one?
First one, my lords. Now on the last date of hearing, this honorable court was the opinion that we would want to know what has happened.
First one, have they filed a charge sheet?
First one, my lords, they have tied it and kept it with themselves, my lords, because the CBI.
We'll dismiss the first one. Let the second one remain.
My lords, as per my lords.
Second one, they have filed charge sheet.
Second one, they filed charge sheet. The CBI has filed the charge sheet.
So second one has to be dismissed because first one is pending.
My lords.
First one, according to you, the same thing you did, tied it. So we'll remove the tie and we'll dismiss the first one and let the second one be there because charge sheet is there.
My lords, I will have to then convince my lords that my lords, as per the Supreme Court, my lords, and my lords also of this court, my lords, the initial FIR would sustain, my lords, the subsequent FIR would have to go.
Yeah, in a case where the charge sheet is not filed,
in a case,
does
my
the
lords,
judgments cover that also?
My lords. My lords. If I may be permitted, my lords, on the last order sheet, if my lords will see.
Argument.
My lords, before starting my argument, I would not want to waste the time of this court. Last order sheet, the state was directed, my lords, to keep the diary ready, my lords, because the division bench number 2 was also of the opinion.
Charge sheet नहीं है.
First में, my lords,
charge sheet नहीं है. Second में है.
जी.
तो डायरी का क्या जरूरत? देखो.
My lords, the charge sheet, my lords.
Judgment.
Judgment.
डायरी किसके लिए चाहिए?
My lords, on the last date of hearing, the DB number 2 said that we want to see the contents of the, we want to see the contents of the
Why
first.
should see the content? Charge sheet is filed now.
Charge sheet is filed.
Good, bad, ugly is not our problem. Magistrate has to decide it.
My lords.
Why we must read it?
Now, my lords, then my argument would be on two grounds, my lords.
First or second?
Second ground would be, first, my lords have taken my lords into consideration.
With the judgment. Have you filed charge sheet in the first FIR?
Yes, Lordship. Reply has already been filed on the part of the CBI, Lordship.
First one.
Last time it was directed for the state government to file the charge sheet, Lordship. It has been done or not?
Oh, state government.
Yes. Last time there was a direction by the DB number 2.
You are by one case by CBI, one by state, is it?
Yes.
Subsequent FIR has been registered by the CBI, Lordship.
Ah.
First FIR was registered by the state.
If my lord will just take para 11 and 13, my lords.
Is it arising out of the same?
Same, identical complaint, identical representation, identical grounds.
What is it?
If my lords will just see my petition. My lords will just take MCRC 8239, my lords. The initial FIR, my lords will find at page 25. Now, my lords, that is dated 1/8/2020.
What are the allegations then?
The allegations, my lords, in concise, I will say, my lords, that as per section 312 and 14, my lords, of the Press Registration Act, my lords, there is a certain number of circulation that I have to show of my newspaper to get the contracts from the government, my lords, for publications of advertisements by the government, my lords.
Yeah.
Now, my lords, they say that I do not possess that much of circulation in that particular district. And by deception, I have taken that contract from the state, from the government. Now, this FIR gets registered, my lords, against me in the relevant sections, my lords, by the local police station. Now, my lords, they approach after
the advertisement for what period of time?
For a year, my lords. For
Which
a year.
year? Which year?
If my lords, we have placed that also on record. If my lords will just see annexure P8 at page 34.
We will not see anything. You just tell us.
I'll just point out. My lords, this is for the time period from 1/1/2019 to 31/12/2021.
Second FIR is for what period of time?
Same. My lords. My lords, the second FIR we have placed on record as annexure P6 at page 29.
Yes.
P6 at page 29. This is after a year, my lords. Dates are important.
First FIR is filed when?
First FIR is, my lords, 1/8/2020.
Second FIR?
Second FIR, my lords, is 4/10/2021.
4/10/2021. So that is for what period? Second FIR?
My lords, I'll read, my lords. I'll read. A written complaint dated 13/8/2021. A written complaint dated 13/10/2021 has been received by Mr. Himanshu Kaushal at the CBI ACB Jabalpur branch, alleging that two newspapers, namely Dainik Dal Sagar and Dainik Yukshesh District Sivri, and one newspaper, namely Dainik Jailok of District Jabalpur, are receiving So, my lords, the same representation which goes before the local police station for that same time period, my lords. But that time period.
No, read the FIR. It is from 13 to 21.
13 to 21, my lords. My lords, that is merely what they have stated in their representation.
No.
Now, my lords will just see. My lords will just see. Even if that is the case, if that is the case, I will
try to satisfy, my lords.
Not even that is. You are supposed to tell us what is the case.
The case is, my lords, the case
As
is,
far as the first complaint goes, it is for a different period. Second complaint is for a different period.
my lords, that cannot be, because the second complaint, the period,
That cannot be, that the trial judge will decide.
the trial judge,
This is not overlapping of the same offense for the same period of time.
my lords, it is this, the contents have to be seen, my lords. The time period, he will put anything that he wants, my lords, the time period.
Content will be the same. It's the same allegation against you. But the period is different.
My lords, then,
for one period, it is 19 to 21. For others, it is 13 to 21.
my lords, then can I address on the second ground that we are raising, my lords?
You first.
Second ground also is of consideration insofar as the CBI FIR is considered.
You are not telling the facts correctly.
My lords, the CBI FIR, my lords. My lords, the CBI FIR, my lords, is only registered because they have alleged that certain officers of the Broadcasting Corporation are also involved in the entire issue, my lords. Now, when they file their charge sheet, they only file their charge sheet under section 420 against 3 private people, out of which 1 person is dead. My second argument would be, my lords, that the CBI cannot be, the trial cannot go on, my lords, where there are no public servants involved. So if my lords will just take up my application, my lords,
What is the stage of the trial?
My lords, we have to argue on the charge, my lords. We have to argue on the charge before the CBI. So my only contention would be, my lords, because this honorable court has put pace.
Even narrating your facts properly. The case in the first one.
The case in
what is the period? What are the sections? What is the second case? What is the period? What is the section?
My lords, I will again demonstrate, my lords. The first FIR, my lords, have gotten the dates, my lords. The period that is mentioned, my lords, is from
Where is the first FIR?
that is Annexure P5, my lords, at page 25.
20?
25. Page 25.
What is the period here?
My lords, the period which is mentioned, my lords, is 30th January 2020 to 31st January 2020. 1 day. Occurrence of offense, my lords. That is what I am trying to demonstrate.
Where is the complaint, Mr.?
My lords, the first information, if my lords will come at page 27. Page 27 now, he says, my lords, the officer who is registering the FIR. मैं थाना कोतवाली सिवनी में उप निरीक्षक के पद पे पदस्थित हूँ। आवेदक हिमांशु कौशल पति सोएनसो चौकी सिवनी द्वारा अनावेदक दैनिक दल सागर समाचार पत्र सिवनी व दैनिक युगशेष समाचार पत्र सिवनी के मालिक के विरुद्ध फर्जी दस्तावेज के आधार पर आर्थिक लाभ कमाए जाने की शिकायत थाना प्रभारी डुंडा सिवनी को जांच हेतु दी गई। जो घटनास्थल दिनांक कोतवाली सिवनी क्षेत्र का होने से आवेदन पत्र में दस्तावेज एवं जांच प्रतिवेदन के श्रीमान एसडीओपी महोदय सिवनी के कार्यालय से जांच हेतु थाने पर दिनांक 31/7/2022 को प्राप्त हुआ था, जिसके अवलोकन पर अखबार दैनिक दल सागर सिवनी के मालिक प्रमोद शर्मा पिता बीएल शर्मा उम्र 50 साल सिवनी आचार्यपुरम कॉलोनी न्यू पथरा सिवनी एवं अखबार दैनिक युगशेष सिवनी के मालिक विजय छंगवानी पिता सोएनसो कॉलोनी सोएनसो के का कृत्य धारा 3/5/12/14/15 प्रेस एंड बुक रजिस्ट्रेशन अधिनियम 1867 एवं धारा 420 आईपीसी का घटित करना पाए जाने की कायमी की विवेचना में लिया गया। नकल आवेदन पत्र नियम अनुसार प्राप्त। थाना प्रभारी महोदय थाना डुंडा सिवनी तहसील जिला सिवनी मध्य प्रदेश। विषय now my lords, this is the representation which they have put down again, my lords.
Yes.
Now my lords, he places it on 3 counts. One, he says यह कि सिवनी जिले के अनेक लोकल अखबार प्रकाशित होते हैं, जिनमें कुछ अखबार सरकार के विज्ञापन सूची में हैं। सरकार इन अखबारों को
इनके प्रसार संख्या के आधार पर विज्ञापन प्रदान करती है। 2, यह कि सरकारी विज्ञापन प्राप्त करने हेतु सिवनी जिले से प्रकाशित दैनिक दल सागर अखबार एवं दैनिक युगश्रेष्ठ अखबार द्वारा फर्जी दस्तावेज के आधार पर अपना प्रसार संख्या वास्तविक से कई गुना बढ़ाकर फर्जी तरीके से दर्शाई जाती है, जिसके आधार पर उक्त दोनों अखबारों की प्रतिवर्ष 18 से 20 लाख रुपए के विज्ञापन प्राप्त होते हैं। थर्ड, ही सेज सरकार के सूचना एवं प्रसारण मंत्रालय के अधीन DAVP के वेबसाइट में दैनिक दल सागर एवं दैनिक युगश्रेष्ठ की प्रसार संख्या लगभग 35 हजार प्रतिदिन दर्शाई गई है, जबकि जिला कलेक्टर जिन्होंने संख्या सत्यापन के अधिकारी शासन द्वारा प्रदायित रिपोर्ट के अनुसार दैनिक युगश्रेष्ठ की 18 व दैनिक दल सागर की 22,000 प्रति प्रदान की गई है। now
Yes.
Now, my lords, if my lords will see the subsequent FIR, my lords, by the CBI, identical representation they talk about that we have received this representation. On this representation, we are registering the FIR. Now, my lords, what the Supreme Court says, my lords, I'm citing.
You leave Supreme Court alone.
My lords,
And to read facts.
my lords. Now, my lords will just come to page 31.
Who are they accused in the first complaint?
My lords, there are 3 newspapers whose editors he has made the accused, my lords. They are Mr. Pramod Sharma, Mr. Vijay Chhangwani, and one Mr. Ajit Kumar, my lords. Mr. Ajit Kumar has already passed away, my lords.
So there are 3 accused.
There are 2 now, remaining 2. 2, my lords. Now, Mr. Vijay Chhangwani and Mr. Pramod Sharma are before, my lords. The connected, my lords, would be Vijay Chhangwani. 2 MCRCs, my lord.
Where is the second FIR?
The second FIR, my lord, will find at page 29, Annexure P6. Now, my lords, here the offences which are registered, my lords, are also under section 13(1)A, read with 13(2) of the Prevention of Corruption Act. My lords.
What is the complaint here?
The complaint here, my lords, will come at page 31, my lords. A written complaint dated 13/8/20 has been received by Shri Himanshu Kaushal, the same person, my lords, at CBI ACB Jabalpur branch, alleging therein that 2 newspapers, namely Dainik Dal Sagar and Dainik Yugshesh, District Sivni MP, and 1 newspaper, namely Dainik Jailok, District Jabalpur, are receiving advertisements worth lakh of rupees from the Directorate of Advertisement and Visual Publicity, DAAVP, an agency of the Government of India, now Bureau of Outreach and Communication, BOC, for the last many years on the basis of forged report of chartered accountants, which in regard to their circulation. This is exactly what I have read, my lords, in the Hindi FIR. It is alleged that in the complaint that Dainik Dal Sagar, Dainik Yugshesh and Dainik Jailok are small category newspapers, but they have registered themselves in the medium category by showing false enhanced circulation. The reason behind is that the advertising rate are different from small category and medium category, and the provision of budget of medium category is approximately double to the budget of the small category. Therefore, the small category newspapers should have received less advertisements from the government and should have been paid with the lower rate for the advertisement awarded to them. However, on the basis of forged report of CA, by showing higher circulation of the newspaper, they have received more advertisements and have also received payments with a higher scale. It is alleged that DAVP/BOC does not get verified the documents submitted by the owners of the newspaper. Further, they did not act upon the report of the state government provided to them after inquiry into the said allegations. Thus, during the last 8 years, Dainik Yugshesh has been awarded and paid the advertisement amounting to rupees 21,11,017. Dainik Dal Sagar has been awarded and paid rupees 9,51,643. And during the last 3 years, Dainik Jailok has been awarded and paid for advertisement amounting to rupees 2,66,000. The allegations levied in the complaint prima facie disclose commission of a cognizable offence of criminal conspiracy, cheating, forgery for the purpose of cheating using forged documents as genuine, and criminal misconduct by the accused person, namely Shri Pramod Sharma, Shri Vijay Changwani, so and so, and Mr. Ajit Kumar Verma, who's already passed away, my lord, publisher, editor of Jailok, and other known public servants. Other known public servants of then Directorate of Advertisement and Visual Publicity, now Bureau of Outreach, and Commission of BOC, which is punishable under the sections 120B, 420, 468, 471 of the IPC, and section 13.2 read with 13.1A of the PC Act, as amended so and so. Hence, FIR is registered accordingly.
What is the present situation for both the trials?
The initial malos, the first FIR malos, they have yet to file the charge sheet. The CBI has filed the charge sheet against only two who are before my lords under section 420. And in the charge sheet, they say that there is no offences against any of the public servants. And that 420 is also in the first.
Second charge sheet, what happened?
Second charge sheet is before the CBI court, my lords.
Trial has commenced.
It's on the stage of charges. We have to argue on charge, my lords.
So my submission is that loss of the trial has to be commenced, as he has to first appear before the special court CBI lordship in order to make out its case for the discharge. If he has been of this opinion that the second FIR should not be registered, subsequent to the first FIR as registered by the state government. Here I've made it very clear in my reply, lordship, the second FIR as has been registered by the CBI in relations to finding out the involvement of the officials from the central government, because it is not the state government who can register the FIR against the central government employee. Here there has been the involvement of the BOC, that broadcasting of the. This loss may kindly appreciate. In the reply, loss which has been filed, this loss may kindly appreciate paragraph 16. It's on page 5, loss. Also, what I've submitted in reply will also be in paragraph 16. Should I read just one paragraph also, just to substantiate as to why the second FIR has been registered by the CBI?
They are employees of the central government.
Yes. Only in relation to finding out.
So far as the first FIR is concerned,
it has been registered by the state against the state officials also. So there is no, he cannot get the benefit of that judgment loss which he has been relying. That there is a FIR.
Why you are not filing charge sheet?
The instructions as to what it is.
Huh? The complaint was lodged in which year?
1/8/2020.
What is the problem?
This filing was not done.
Take it tomorrow.
Tomorrow.
My IO and
because it's concluded, but my lords, what my learned friend has just stated, that second FIR they have registered because the involvement of the central government officers. The charge sheet is on record, we've already filed. The charge sheet has only been charge sheeted against two people, Mr. Pramod Sharma and Mr. Vijay Changwani, only under section 420. There is no sections of the PC Act. There is no government officer who has been charge sheeted or even named in the FIR.
Is that correct?
Also, so far as the charge sheet is concerned, also this, that
you said central government officials are there.
Also, initially FIR was registered in accordance with the provisions of the PC Act also. But
charge sheet hai na?
Yes, charge sheet.
Kiske khilaf hai charge sheet?
Charge sheet has been filed also that against these two persons also.
Get ready, Mr. Don't waste time.
And there are two other persons also.
How can you go behind the FIR now? तो फाइल चार्जशीट, ट्रायल हैज टू गो अगेंस्ट हूम?
Charge sheet has been filed.
एफआईआर में है, उनके पीछे जाते हैं जो चार्जशीट में है।
Charge sheet has been filed.
फिर वो क्या कह रहे हैं, आप क्या कह रहे हो?
Charge sheet has been filed also.
If they are not there, then how you can do it against the same people? That is his argument. कर ले।
I'm obliged, Manoj.
Yes.
My lord, earlier notices were issued in this case, lordship.
हाँ.
And our notices have been served. लेकिन कोई appear नहीं हुआ respondent side में.
What happened?
Lordship, the daughter filed the application before the family court, lordship, for seeking 7 lakh rupees for her marriage, but she did not enter into the witness box, lordship. So witness box में she did not appear, but trial court, without appearing, the non-applicant in the witness box awarded 4 lakh rupees. इसमें लॉर्डशिप हमारा कहना है कम से कम लड़की नहीं लाए, लड़की को आना चाहिए किस लड़के से शादी कर रही है, लड़का कौन है, क्या है.
When is the marriage?
नहीं, कोई डेट नहीं है अभी मैरिज आने की. वो आई ही नहीं लॉर्डशिप, विटनेस वक्त में आई नहीं ना, उसने बताया कब.
डॉटर ना,
डॉक्टर.
You don't want to spend money?
नहीं, नॉन एप्लीकेंट इज रेडी, लेकिन पता तो चले लॉर्डशिप लड़का कौन है, कब शादी किससे कर रही है.
वो सभी हम बोलेंगे. आप कितना खर्च करना चाहते हैं?
उन्होंने तो 7 लाख रुपए मांगे, 4 लाख रुपए ट्रायल कोर्ट ने दिया है.
हाँ.
तो हमारा कहना ये कम से कम न तो वहां आई वो विटनेस वक्त पे अपनी एप्लीकेशन प्रूव करने के लिए.
तुम विटनेस शादी पर कितना खर्च करने के,
जो भी खर्चा होगा लॉर्डशिप फादर करेंगे, लेकिन लड़का कौन.
7-8 लाख होने वाला है.
लॉर्डशिप कम से कम लड़की आ तो जाए, बताए तो लड़का कौन है, देख तो ले पिताजी लड़के को कि लड़का कौन है, क्या करता है.
पहला पैसा जमा करो, सब आ जाएंगे. कोर्ट में डिपॉजिट कर दो 7 लाख.
तो उसको डिसबर्स न करें लॉर्डशिप, डिसबर्स पे रोक लगा दें आप. 4 लाख की हम 2 लाख जमा कर देते हैं यार.
7 और 2 लाख.
नहीं, 4 लाख नीचे से अवार्ड ही हुआ है.
7 और 4
नहीं, 4 लाख अवार्ड हुआ है नीचे से.
डिपॉजिट कर लो.
डिसबर्स ना करें उसको, डिसबर्स ना करें.
नहीं करेंगे, यहाँ ही रखें. डिपॉजिट करेंगे,
कर देंगे लॉर्डशिप, दिक्कत नहीं है.
दिक्कत नहीं है तो साथ ही कर दो.
नहीं, लड़का तो आए सामने.
4 के लिए दिक्कत नहीं है, 7 के लिए थोड़ा दिक्कत है.
हमारा कहना है लॉर्डशिप कम से कम लड़की सामने आए.
जब आएगा, शादी रेडी होगा, तब पैसा रिलीज करेंगे. आप पहले रख लो कोर्ट में. शादी के लिए चाहिए ना,
शादी के लिए. जबकि हमारे मकान में ही रह रही, वाइफ से इनका वो हुआ है, अलग रहती है वाइफ इनकी बच्ची के साथ, इन्हीं के मकान में रहती है वो.
Where is your wife?
वाइफ अलग रहती है लॉर्डशिप, उनको 5,000 रुपए मेंटेनेंस हर महीने मंथली देते हैं ये.
और डॉटर को?
डॉटर भी उन्हीं के साथ रहती है, मतलब हमारे ही मकान में रहती हैं. डॉटर 18 की हो गई तो अभी उसको मेंटेनेंस नहीं है. हमारा मकान है, सब कुछ है. हमारे फादर जो थे उन्होंने
पेट नहीं भरता ना.
नहीं, हमारे फादर ने पार्टीशन प्रॉपर्टी दी है दोनों को. हमारे फादर ने पार्टीशन में इनको प्रॉपर्टी दी है, वाइफ को और बच्ची को.
क्या दिया है?
जमीन वगैरह दी है और काफी सामान दिया है इनको कि भाई ये ताकि रह सके. और हमारा कहना है कि लाएं तो किस लड़के से मैरिज कर रहे हैं, कम से कम लड़का सामने आ जाए, क्या करता है क्या नहीं करता, वेदर शी इज फिट फॉर माई डॉटर और नॉट. लड़की आई नहीं विटनेस बॉक्स में, बस सिर्फ इतना कह दिया हमें शादी करना है. तो यहाँ भी नहीं आई लड़की, यहाँ से भी नोटिस हुआ तो कम से कम यहीं आके बता देती हो. हमारा इतना ही कहना था, कम से कम एफआईआर होके कम विद क्लीन हैंड बता तो नहीं है टू whom she want to marry.
मर्जी है, कहीं भी शादी करेंगे.
अब फादर से लॉर्ड से पैसा चाहिए तो फादर का इतना हक तो बनता है कि वो देखे कि
आपको इनवाइट नहीं करेंगे. नहीं,
हमें इनवाइट ना करे, कम से कम लड़का तो हम देख लें लॉर्डशिप क्या करता है, वो ना बुलाए हमको.
एक और प्रेस नोटिस लेटर वो 4 लाख याद रखेंगे हम
हम
next time. We issue notice to respond. स्टे एप्लीकेशन किसके लिए?
उसी के लिए लगाया था लॉर्डशिप, पैसा जमा करने के लिए एक्सक्यूशन कर रही है ट्रायल कोर्ट।
एग्जीक्यूटिव कोर्ट में है?
हाँ, एग्जीक्यूटिव कोर्ट में चल रही है, एक्सक्यूशन चल रहा है। डॉक्टर ने एक्सक्यूशन पेश कर रखा है वहाँ।
कौन है उसका वकील? नाम दीजिए ना, उनको नोटिस दे देंगे।
एडवोकेट का नाम हम पता कर लेते कौन है लोअर कोर्ट में उनका एडवोकेट एक्सक्यूशन केस।
अगर ये ऑर्डर वो लोग एग्जीक्यूट कर रहे हैं,
हाँ कर रहे हैं
तो
लोग,
यहाँ नहीं आ रहा है,
यहाँ नहीं आ रहा है,
वहाँ के लॉयर को दे देंगे ना नोटिस।
हम पूछ लेते कौन है उनका लॉयर वहाँ पर।
तो कल ले ले,
रख दे कर, ये ऑर्डर कर दे नोटिस का, हम एडवोकेट को पूछ के दे देंगे।
नहीं, सर जनरल नहीं करेंगे, उनका नाम बताइए, डायरेक्ट उसी को देंगे।
ये विनोद पस्तोर है लॉर्डशिप, विनोद पस्तोर, विनोद पस्तोर।
To take out notice on
Vinod Pastur,
learned counsel appearing for the respondent in execution case number so and so before the court number so and so.
Right.
Showing the date of appearance as 20.
Right.
Till then stay of the order dated so and so. Urgent hearing disposed.
Lord. My lord, amount of 20,000 will be deposited.
For what?
My lord,
Release of the vehicle.
for the release of the vehicle because he has
Pay 20 lakh.
My lord,
just 2 lakhs.
my lord, he has deposited 2 lakhs rupees, your lordship.
उसके अलावा?
My lord, 20,000. My lord.
Right.
Within 15 days or any time, my lord.
अरे तुम टाइम बोल दो, फिर एक्सटेंशन
Within
4 हफ्ते दे देंगे।
मतलब 15 days, my lord.
Within a period of 4 weeks and vehicle to be released as and when payment is made. It is 25,000, 20,000 in addition to
2 lakhs. That
My lord, that has
already
been
deposited.
already
That has been
deposited.
deposited.
or to penalize him, that's all. Otherwise,
My
it is already an order, no?
The amount has been realized.
Okay. Please speak, Mishra.
Your Lordship, I have taken for time till tomorrow to ascertain with regard to the service of the warrant. I have sought information from the authority.
We should be bailable, na?
Yes, my lord.
Huh.
For returnable for 26. 27.
All day after at request of response government. For all of them, you have to file a report, counsel.
Yes, my lord.
Then
We will.
enforced in this particular state that we are searching for that.